Okay, we just began our live stream. Welcome, everyone. We just did a conflicts check and introduced ourselves to each other kind of informally before we started this trial. And so right now we are going to swear in our advocates. If everyone could please raise your right hand and indicate by saying "I do" if you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I did.
Great, thank you, everyone. As we mentioned earlier, it looks like both teams have all of their advocates and witnesses here. We have our scoring jurors, and I am your ruling judge. We are all here. We're ready to proceed. So we will now call case number 082263, Cam Donaldson versus Karen Baja. My understanding is both sides have a couple of procedural matters to attend to before we go to substantive motions and the trial itself. So why don't we go ahead and take up any housekeeping or procedural matters from the plaintiff's side?
Your Honor, as we make objections throughout the case and ask to approach sidebar for evidentiary arguments, may we assume the sidebar is constructive and simply remain in this Zoom room?
Absolutely. I think we have to do that. Thank you for bringing that up. We can assume limiting instructions are constructive, sidebars are constructive, approaching the bench, anything to that effect are all constructive.
And once an exhibit is entered into evidence, may we publish those exhibits by using the screen share function?
Assuming that anything you share in the screen sharing is not in violation of any of the local rules that I don't know about. For example, maybe you're not supposed to share the witness statement with me or whatever it is. I don't know if that's a thing or not, but assuming that anything you share is not in violation of the local rules, you are allowed to do that. Both sides are.
Okay, great. And we have prepared a PowerPoint to use during opening statement. We've showed opposing counsel and they have no objection to the content of the PowerPoint. May we have the court's permission to use it during opening statement?
And I'm sorry, you said that the other side does not have an objection?
That's correct, Your Honor.
Yeah, absolutely. You can do that as well.
We just want to put the court on notice that normally we would ask to sequester the witnesses pursuant to Rule 615, but since the witnesses in today's case are all parties and experts, we are not seeking sequestration.
Okay, so defense, are you fine with that? Do you have any issues with not sequestering witnesses?
No, Your Honor, we have no objection to that.
Great, thank you. Okay, anything else, Ms. Stern?
Your Honor, that concludes our procedural matters. May we proceed with the substantive motions?
I think let me ask the defense's side if there are any other procedural matters before we do substantive motions.
Yes, Your Honor, before we move on to preliminary matters, the defense does have a document to tender to the bench. May my co-counsel tender that via chat to you?
Is this like a piece of evidence or?
I'm sorry, a notice of appearance. My mistake.
Oh, certainly. Yeah, that's fine.
Right, she should be sending that over chat to you soon.
Who is Evan Savati? Is that someone that should be admitted?
I believe that's one of our trial team people that's trying to get in. We've let them know otherwise.
Okay, so I think I'm just gonna remove Mr. Savati so that he can watch it via live stream, which I know is on right now.
Yes, Your Honor. And the chat function isn't working. We didn't realize that was going to happen. So constructively, we will tender the notice of appearance to you.
That's fine. And you know what I'm going to do, since we introduced ourselves to each other before we started the live stream, I'm almost going to consider that as if it was off the record. So for the record, we will redo entries of appearances once you finish your preliminary matters.
Yes, Your Honor. So before we proceed to the preliminary matters, would you like a brief recitation of the facts?
Yes. So first, does the defense have any more preliminary matters? I didn't hear them say whether that was it or not.
Oh, yes, Your Honor. The defense does have a few more preliminary matters.
Okay. Hold on. So, Ms. Maxwell, I guess I'm asking for just like housekeeping stuff, and then we'll get to motions and limine. starting with the plaintiff's side. Do you have any more housekeeping stuff?
Yes, Your Honor. We would request to know if it's permissible for us to enter evidence in opposing counsel's case in chief if necessary.
I think it's going to depend. That's a little unorthodox, but it sure isn't necessarily prohibited. And so, I mean, if you're entering evidence through cross-examination, then sure, if it works and you lay foundation for any piece of evidence, then you can enter it that way.
Thank you, Your Honor. Additionally, may we confirm that the federal rules of civil procedure and evidence are in effect in today's case?
I'm assuming both parties agree. I believe those are the rules that are governing.
And Your Honor, with that, we're ready to move on to motions in limine.
Okay, so before we do that, because we introduce ourselves off the record, why don't we formally have entries of appearances? We'll start with the plaintiff's side. My apologies for taking this out of order.
No problem. Good evening, Your Honor. My name is Jen Stern, counsel for the plaintiff, and I, along with my partner,
Terrence Jones,
represent Cam Donaldson in today's case. We are Team Mount and Taro.
Good evening to both of you. I know it's probably not evening wherever you are, but it is here, so good evening.
It is here as well, Your Honor.
Great. And let us get entries from the defense, please.
Your Honor, my name is Rachel Maxwell, and along with my co-counsel,
Corey Posey.
we represent the defendant, Karen Baja, in today's case.
Excellent. Thank you both. So going to the plaintiff's side now, my understanding is you have some motions in limine to attend to. So why don't we go ahead and hear those?
Your Honor, we only have one motion, but I just want to put the court on notice that the parties met pre-trial and have agreed that neither party will reference or use 3 photographs found on pages 60 to 62 of the record.
Is that the defense's agreement as well?
Yes, Your Honor.
Okay. If, because I haven't seen those photographs, if either party does admit or attempt to use it, I'm sure the other side will jump up and let me know. I'm not going to know which photographs you agreed on, so please let me know. And thank you for working together to agree on the motion.
But it is our understanding that you have a copy of the exhibits in this case. Is that correct, or does Your Honor need a copy?
I do not personally have a copy of the exhibits, but I will find out if I should have had a copy of the exhibits here in a moment.
Okay, if Your Honor does not, we're happy to provide that for you.
Okay, excellent. I'm assuming you're going to probably publish the exhibit once it is admitted anyway. Is that right?
Yes, Your Honor.
Okay, then I think we should be fine. Great. Any other motions from the plaintiff?
Yes. By way of background, and as the court is aware, this is a wrongful death action that Cam Donaldson filed against the defendant, Karen Baja, asserting that she killed her father, Lou Donaldson. We are seeking an affirmative ruling regarding 2 statements that sort of go hand in hand made by the decedent. Just 2 weeks before Lou Donaldson died, the plaintiff overheard her father and the defendant having a very heated argument during which Mr. Donaldson told the defendant he was going to file for a divorce. Immediately after that fight, Lou Donaldson came out visibly shaken, and Cam Donaldson will testify that she had never seen her father like that before. In that moment, while still shaken, Lou Donaldson told the plaintiff, "If anything happens to me, tell the police to look at Karen because she will be responsible for my death." The statement that he planned on getting a divorce is admissible under Rule 8033 to show Lou Donaldson's state of mind. And the second statement, the one he made to Cam Donaldson right after the fight, is an excited utterance.
And the second statement being, if anything happens to me, look at this person?
Correct.
Okay. And so you're seeking to admit both of these statements?
Yes, Your Honor.
And I'm assuming the defense is objecting to the admission of both of these statements?
Yes, Your Honor, that's correct.
Okay. What is your response to the motion?
Your Honor, these are hearsay statements. They're clearly inflammatory and will be used for the truth of the matter asserted. Additionally, other than the witness's own testimony, there's no other evidence that these statements were actually made in a situation that would qualify them for the excited utterance exception.
Okay. So unfortunately, excited utterance is one of those things that takes quite a bit of foundation to lay. If the foundation is laid for excited utterance, then I might be willing to let it in. But unlike a lot of other evidence, hearsay is a little bit difficult to rule on pre-trial. So I have heard both arguments, but I don't think that I know the case well enough to make a ruling. I'm going to have to reserve ruling on that motion.
Your Honor, we were planning on using that statement or referring to it during opening statement. Would you prefer that we do not do so at this time?
Well, what I will tell you, Ms. Stern, is opening statement is a preview of the evidence. And if you believe and you have a good faith basis that this should be able to come in, then you can use it in your opening statement. And if you end up not being able to bring it in, I'm sure the defense will tell the jury in closing argument that you're just making stuff up. So I'm going to leave that up to you, but make sure you have a good faith basis that it will come in order for you to use it.
Understood, Your Honor. That concludes our substantive motions. The plaintiff is prepared for opening statements.
Thank you, Ms. Stern. And I'm assuming Ms. Maxwell, are you doing motions?
Yes, Your Honor, I am.
Okay.
The defense has two motions to take before the court today. First, the defense moves to exclude any mention of statements purportedly made by Ms. Samantha Lane. By way of background, Ms. Lane was a witness to Mr. Donaldson's last will and testament, which is at issue in today's case. She purportedly made statements to the plaintiff's investigator witness, verbally denying that she saw Mr. Donaldson sign this will, and also purportedly wrote a letter to the defense's investigator alleging the same thing. Ms. Lane is not testifying today, so any mention of these statements are inadmissible hearsay with no recognized exception.
Okay, and so we have a written letter from her and verbal statements that you're seeking to exclude? Yes,
Your Honor.
Okay, plaintiff, what is your position on the letter from Ms. Lane?
As far as the letter, Your Honor, we do intend to introduce it, and it is admissible pursuant to Rule 703 regarding the underlying basis of the expert's opinion. The defense expert will be forced to admit on cross-examination that he received this letter from Samantha Lane, and the defense's expert completely disregarded it. Because the jury has to weigh the credibility of the expert's testimony, they should be able to hear what he did and did not consider in coming to his opinion. The fact that one of the two alleged witnesses to the will says in this letter that she never saw Mr. Donaldson sign the will, and the expert completely ignored that, goes directly to the expert's credibility.
Okay. Defense, do you have any response to that? It sounds to me like plaintiff may use this on cross of your expert for impeachment purposes.
Yes, Your Honor. I believe that would be using the expert as a conduit for inadmissible hearsay. This is inflammatory statements that she made, and I think they will be used for the truth of the matter asserted. But if Your Honor finds that the letter is admissible, we do ask that the specific contents of the letter at least be constructively redacted.
Okay, and I think that might be fine. What I will tell you guys is I am leaning towards letting this in, assuming sufficient foundation is laid, based on what I have heard from Ms. Stern about what the defense's expert ignored. Having said that, if during that cross-examination, it doesn't seem like it is the appropriate witness to bring this in with, then Ms. Maxwell, feel free to raise that objection. We'll go to sidebar and readdress this motion. What I'm telling you, though, is I am leaning towards letting it in. Obviously, we can constructively redact anything that is inadmissible in there.
Yes, Your Honor. Before I bring up my second motion, I have lights that have timed out on me, so I'm going to just move around just
Okay.
a little bit to
You're
let
gonna move around a little bit? Okay, I thought you were setting the ambiance for us.
No, it's an intense case, but I won't set the mood that way. Now, the second motion that we have to bring before the court is that the defense excludes to, or moves to exclude, excuse me, the request for temporary restraining order that Mr. Donaldson sought against his wife, my client. By way of background, about 2 months before he disappeared, Mr. Donaldson filed to request a temporary restraining order against his wife. We anticipate that the plaintiff will try to bring this in to prove that she had something to do with his disappearance. This order and the allegations therein are inadmissible hearsay with no recognized exception. And furthermore, because the judge denied this order, it would violate the principle of res judicata.
Ms. Stern.
Your Honor, we do intend to introduce the temporary restraining order. May I use the screen share function to show the court the document itself?
Yes, and obviously we're going to assume that the jury is not seeing this. The jury is not hearing any of this. These are motions pre-trial. So go ahead.
Are you able to see that, Your Honor?
I am.
I'd first like to make the court aware that in their answer to our complaint, defense counsel admitted that this temporary restraining order was filed by Lou Donaldson against the defendant. So the fact that it was filed is admissible. The contents of this document are admissible hearsay for several reasons. As Your Honor can see, the statements written by Lou Donaldson show his state of mind or his statements of intent at the time that he filed this, and therefore are admissible under Rule 8033. Secondly, we're going to have an expert testify today regarding Lou Donaldson's signature and whether or not the will that the defendant was paid under was valid. The expert took this document into consideration in making his expert opinion, and so therefore under Rule 703, it's also admissible as an underlying basis of the expert's opinion. And lastly, and frankly, the most important, this document is admissible because it provided the defendant with notice and created a motive for her to kill her husband, because leading up to his death, he planned to get a divorce and even filed with the court that he didn't feel safe around her. This defendant would not take no for an answer and took matters into her own hands by killing Lou Donaldson so as to avoid getting a divorce and instead received all of his assets.
You mentioned that there was a witness who can testify to the victim's fear of something. Did I misunderstand that, or did you say that?
Well, as far as this restraining order, the witness that I was referring to is our expert witness who used this document in coming to his expert opinion. And so therefore it is admissible under Rule 703.
Okay, any final word from the defense on this issue?
Yes, Your Honor. Regarding their 8033 argument, that exception does not apply to beliefs held by the declarant, and these three grounds are beliefs that he would have had, and so 8033 does not make them admissible. Further, the argument that this will be basis for an expert testimony, I don't believe that the plaintiff will be able to tender their witness as an expert in investigation or anything not related to forensic document examination or handwriting analysis, and therefore this would not go to their conclusions in those ways.
Okay. I have an issue admitting a restraining order, mainly because I think any trial lawyer will have heartburn when they hear of a restraining order being attempted to be admitted, unless it's a trial on violating a protection order or something to that effect. So I am leaning towards excluding this. Having said that, if there is a witness, including an expert, who has the opinion somehow, and again, this would have to take some personal knowledge or foundation if it's an expert, that the victim was fearful or they have evidence that the victim was fearful of the defendant prior to his death, and this is what they're referring to, it is possible that I might let that testimony in without referencing that it's because they read it in a temporary restraining order. I don't know if I will let it in because I need to hear that testimony. But what I'm saying is, if Ms. Stern, if the purpose for you to introduce this is to show that the defendant was fearful, or excuse me, the victim was fearful prior to his death, and you can probably still elicit that without bringing in this restraining order. I'm leaning towards excluding this, also for the propensity rule. I think this is 404 evidence. So that will be my ruling. I know it's not as clear as you would like. I don't want you mentioning the restraining order in your opening statement for sure, simply because it will take a lot for me to admit the restraining order in its entirety, or even mention the fact that there was a restraining order. And do you need any clarification from either side?
No, Your Honor, I think we're good, and we're ready to move on to openings with that.
Your Honor, if I may, just for purposes of clarification, it is a stipulated fact that there exists a temporary restraining order. So I just want to make sure that it is okay to mention the existence of a restraining order, but not the contents of what is within it.
No, you can't mention the, I'm sorry, you can't mention the existence of a restraining order.
Yes, Your Honor.
I think that, let's say I happen to be someone who knows the victim, and the victim said to me, yeah, I got a restraining order, and I even told the judge that I was afraid of Karen Baja. Then, and if I'm being called to testify, I might be able to say, yeah, I know that he was afraid of her, without necessarily saying because of the restraining order, because of what he wrote. So that's, I guess, what I'm saying. So I don't know if you have a witness who knows the contents of this, who could testify to this, but you can't bring in the fact that there has been a restraining order.
Understood, Your Honor.
Okay. I'm being told that you guys are not seeing this in gallery view, but for some reason I have it in gallery view. Are you seeing this in gallery view?
Yes, Your Honor.
Okay. All right, then I'm just gonna ignore that message. Great. So if we're ready, I think all of the witnesses or the advocates who are not about to be a witness or speak, if you could please turn off your video. And this way it will leave the advocates who are actually about to do the opening statement with their video on.
Your Honor, would you like me to leave mine on as opposing counsel goes? Is that what you mean, or turn it off till he's done?
I think that since are you also doing opening?
Yes, Your
You
Honor.
can leave yours on. And so like when we have a witness on direct, whoever's crossing that witness can still leave their video on. So basically, if you're up from both sides, you can leave your video on. All right, plaintiff's counsel, Mr. Jones, you may proceed with opening statement.
Yes, Your Honor. May I proceed?
You may.
It's Friday. 8 years ago. Cam Donaldson is getting ready to leave work when she sees her coworker, her father, Lou Donaldson, the man who she admires more than anyone in the world. But before she leaves, she realizes that she leaves him alone with the defendant, his wife, Karen Baja. Lou and Cam work at Wild Wildlife. It's a big cat emporium for tigers and lions. But what Cam Donaldson did not know, what Cam Donaldson could not know, was that that day would be the last day she sees her father alive. Because what Cam Donaldson soon realized is what all of you will soon realize, which is that the reason she never sees her father again was because the defendant refused to take no for an answer and instead took matters into her own hands. Cam Donaldson never could have dreamed of filing this lawsuit against her stepmother in order to vindicate her father. But she did, and she had to, because the defendant took matters into her own hands by killing her father. As the plaintiff, we will show you that it is more likely than not that the defendant caused the death of Lou Donaldson through her intentional or reckless conduct. And we're going to do that through two main facts. Number one, the defendant refused to take no for an answer. And number two, the defendant took matters into her own hands. So let's look at these two key facts individually. Number one, the defendant refused to take no for an answer. Today you're going to hear that Lou Donaldson was a self-made man. But the defendant, on the other hand, she wasn't quite so fortunate. That is until she met Lou, because the day that she met Lou was the day her whole world changed. She was able to afford hundreds of cats and millions of dollars. But all of that was put in jeopardy because Lou wanted a divorce that would have left the defendant alone, a divorce that would have left her with no cats and no money. This caused their relationship to strain. It got so bad that Lou Donaldson feared for his life. And he rightfully should have. Because that life would end just 2 months later. This brings us to the second key point. The defendant took matters into her own hands. Today, you're going to hear that the defendant confessed to killing her husband. You're going to hear how she confessed to killing her husband. You're going to hear that the defendant fed her husband to the very cats that he had taken care of for over 20 years. Now, ladies and gentlemen, we understand this is a unique case. And as such, we're not going to be bringing you any eyewitnesses who saw the defendant kill her husband. We're not going to show you any video footage of her feeding her husband to his cats. But you have to understand, this is not CSI. This is not Law and Order. And it's definitely not some crazy Netflix series. This is a civil case. And as such, our burden is to show you that it is just barely more likely than not that the defendant killed her husband. And we're going to be able to show you exactly that, not just through the circumstance, not just through the confession, but through the circumstances. We're going to show you circumstances like Wild Wild Life, the Big Cat Emporium, where they house lions and tigers. We're going to show you circumstances like the meat grinder, a meat grinder so large the defendant will have to tell you a body could fit inside. We're going to show you circumstances like the defendant's supposed alibi. Ladies and gentlemen, when you see all of these circumstances, it will be clear that there are too many coincidences and that the defendant took matters into her own hands. But perhaps one of the most compelling circumstances of all is time. Pay particular attention to the timing of the defendant's conduct after Lou Donaldson died. Pay attention to the timing of the signing of the will. A will in which we will bring an expert to prove was forged. When you consider the timing, it will be clear. The defendant refused to take no for an answer and instead took matters into her own hands. Members of the jury, I want to introduce you to Cam Donaldson. Cam, can you turn on your video feed and so the jury can see you? Ladies and gentlemen, this is Cam. Cam Donaldson no longer has a father. She can't go to the movies and hold her dad's hand. If she decides to get married, she won't be able to hold on to his arm as she walks down the aisle. Cam Donaldson was robbed of these experiences. And as such, she's come before you to tell you to teach the defendant. Teach the defendant that you can't refuse to take no for an answer. To teach the defendant that you can't take matters into your own hands. The only way you can teach this defendant is by bringing back a verdict that's consistent with the evidence. A verdict of liable. Thank you.
Thank you, Mr. Jones. Defense, would you like to present an opening statement?
Yes, just a moment to set up the virtual well.
Absolutely.
Okay, can Your Honor hear me okay?
I can.
May it please the court, counsel, members of the jury. When business owner and multimillionaire Lou Donaldson disappeared, he left everything he owned to his wife of 11 years, Miss Karen Baja. But Mr. Donaldson's daughter, the plaintiff, says this wasn't fair. Well, members of the jury, let us be the first to say, we agree. It wasn't fair that Mr. Donaldson's only child be cut out of his will, but that was Mr. Donaldson's decision. Now, this situation would be hard for anyone to deal with, and you'll hear of all the ideas that the plaintiff has come up with in order to explain her father's disappearance. But no matter the plaintiff's theories or her unwillingness to accept her father's decision, none of that changes the fact that Miss Baja had nothing to do with her husband's disappearance. Good evening, members of the jury. My name is Corey Posey, and I, along with my co-counsel Rachel Maxwell, have the privilege of representing Mr. Donaldson's wife, Karen Baja, in today's trial. Now, the plaintiff wants you to believe that we are here because Miss Baja did something terrible. But the truth is, we are here because the plaintiff cannot accept her father's decision. Now, you will learn that Mr. Donaldson had a pattern of leaving. In fact, when he first met Miss Baja, he was still married to the plaintiff's mother. But he fell so hard, so fast for Miss Baja that he ended up leaving his wife and his child, the plaintiff. This time around, you will learn that the police found no evidence of foul play, no evil explanation for Mr. Donaldson's disappearance. He simply fell in love again. You see, Mr. Donaldson had taken a mistress in Costa Rica, and you will learn that he had been frequently flying off to see her. And then on August 18th, 2012, he flew off to see her again. Only this time he either decided he wasn't going to come back, or he was involved in a plane crash, or he died some other way. We simply don't know what happened to Lou Donaldson. And as such, the plaintiff will not be able to meet their burden in today's case. And let me be clear, the plaintiff holds the entire burden in today's case. They must prove to you 4 things. First, that Lou Donaldson is in fact dead. Second, that his death was caused by Karen Baja. Third, that the plaintiff suffered injuries, losses, or damages as a result of her father's death. And finally, that Ms. Baja was the cause of this too. Now, they must prove to you all 4 things. But the plaintiff won't be able to meet their burden today because no one, not the plaintiff, not Ms. Baja, not the police, no one can even say that Lou Donaldson is dead. And certainly no one can say that Ms. Baja had any responsibility in his disappearance. In fact, later today, you'll hear that the police found no body. They never named Ms. Baja a suspect in her husband's disappearance. And even the insurance company, the people responsible for paying out $5 million to Ms. Baja, they cleared her as having no involvement. Now, later today, you'll learn that Mr. Donaldson did create a will out of either respect for his 11 years of marriage or for the business that he built from the ground up, and maybe even a little bit out of guilt. And he left everything to his wife. And later today, you'll hear from insurance claim investigator Chris Renard. It's important that you remember Chris Renard was hired by the insurance company that he has worked for nearly 20 years, not by Ms. Baja. And Mr. Renard was tasked with the choice of finding out whether or not Ms. Baja had any involvement in her husband's disappearance. He'll take the stand later today and tell you how he's been doing this for years, and it's important that he get it right on the first try. Otherwise, he risks his company facing high litigation costs and maybe even losing his job. Listen carefully, members of the jury. When Mr. Renard tells you he ultimately concluded that $5 million should be paid out to Ms. Baja. We are not here today because of Ms. Baja. We are here today because the plaintiff is grasping for anything to make her father's disappearance make sense. We are here today because the plaintiff cannot accept her father's decision. We are here today because the plaintiff feels entitled to her father's wealth and to his business. But the evidence will show Lou Donaldson told us exactly where he wanted his money to go and who he wanted to take control of his business. That was his wife. His wife, the woman he spent nearly every single day for 11 years with at the cat sanctuary, the woman that he loved until he realized he had a little more leaving left to do. Now, we wish we could give the plaintiff all the answers she needs in order to explain her father's disappearance and in order to accept his disappearance. We stand by the plaintiff that this was not fair. But the fact is, it was her father's final decision. Ms. Baja is not liable for Mr. Donaldson's decision. And the plaintiff cannot ask you to change her father's decision. Once her husband deserted her, Ms. Baja was left to pick up the pieces. She had a business to run, a business rescuing and caring for these sweet exotic cats whom she had come to adore so greatly. Ms. Baja has been dealing with her husband's abandonment for over 8 years now. So at the conclusion of today's trial, we will ask that you finally let her move on with her life and find her not liable.
Thank you, Ms. Posey. Thank you, both counsel. Sounds like we're ready to start with the plaintiff's case in chief. If you will call your first witness.
Your Honor, before we call our first live witness, we'd like to play a video recorded by Exotic Bob. He is unavailable to testify today pursuant to stipulation number 4, but we offer exhibit 1 into evidence.
Any objection from Ms. Maxwell on the defense's team?
Yes, Your Honor. This video contains hearsay within hearsay. While this witness is unavailable, this testimony doesn't meet any of the exceptions that would allow it to come in today, and it's inadmissible on those grounds.
Your Honor, if I may respond.
Sorry, I was looking for the actual permanent mute button for this instead of me hitting the space bar every second. Yes, Ms. Stern, please respond to the hearsay.
In this video, Exotic Bob states that the defendant confessed to killing her husband by feeding him to her, in her words, to her kitties. This is an admission by the defendant, which is clearly admissible as a party opponent admission. Regarding Exotic Bob's statements, they're admissible under Rule 804b6, which allows hearsay testimony against a party that wrongfully caused the declarant's unavailability. Your Honor, we would love to call Exotic Bob live to the stand today, but we're not able to do so because the defendant put him in federal prison by falsely accusing him of a crime, thereby making him unavailable to testify in court today.
Okay, so I understand the layer of hearsay where the defendant's made statement is admission by an opposing party, and you said that Exotic Bob's actual statements are statements against interest. Is that what I'm understanding from you?
They are also statements against interest, Your Honor.
Okay. I do think that assuming that he's made statements against interest in this video, I'm leaning towards letting it in unless, Ms. Maxwell, you disagree that he's made statements against interest.
Your Honor, there is one statement within this video that would qualify as a statement against interest, and the defense has no problem with that one sentence being played. However, the entirety of the rest of the video would not be admissible as a statement against interest. These are not statements that are intertwined with one another. He says in one sentence, Karen Baja and I were engaged in a highly illegal deal, and that would be the entirety of the statement against interest. As to opposing counsel's argument that it falls under the exception for causing the declarant's unavailability, they definitely don't have enough foundation to lay to prove that by the preponderance of the evidence, which I believe is the standard that's applicable to that exception.
Okay. Ms. Maxwell, that's a great argument, but I am going to let the video in. So Ms. Stern, you may go ahead and publish that to the jury. I cannot hear. I don't know.
Mr. Dorash, could you try again and try sharing your computer sound when you share screen this time? One moment, Your Honor.
Certainly, these things happen.
Are you guys able to hear it now?
I am not.
Hey there, I'm Exotic Bob. You probably recognize me as the owner of the world famous I See Spots. I want to thank you for your patronage over all these years. I'm currently a guest of the federal maximum security hotel system. Compliments of one Karen Baja, and that's who I'm here to talk to you about today. Karen Baja walked out of my office. She stopped, suddenly turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob," that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double-cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that. Hey there, evil woman, where you think you're going? We all know where you've been. Hey there, evil woman, where you think you're going? We all know where you've been.
Thank you, Mr. Dorash. Your Honor, with that, we would like to call our first witness, Cam Donaldson.
Okay, Ms. Donaldson, if you will please take the stand and you swear to tell the whole truth. I'm actually going to go ahead and assume that all of the witnesses have been pre-sworn just for efficiency. And thank you for being here today. And Mr. Jones, is it, or Ms. Maxwell, who's actually both of you? Mr. Jones, your witness.
Yes, Your Honor. Ms. Donaldson, please introduce yourself for the jury.
Hi, my name is Cam Donaldson.
Where do you live, Ms. Donaldson?
I live here in Statesville
And how long have you lived here in Statesville?
my whole life.
Well, do you work here?
I did.
Well, what do you mean you did?
I used to work for Wild Wildlife, my dad's company, until Miss Baja fired me a couple of days after he disappeared.
Now, when you say Karen Baja, are you talking about the defendant in this case?
I am.
And who was your father?
House Lou Donaldson.
And what was your relationship like with him?
We were really close. I was always a daddy's girl growing up. We were not only were we just close at home, but he was also my coworker. So we worked together for years.
And where did you all work?
That was at Wild Wildlife. That's where I worked for years.
What is Wild Wildlife?
It's hard to explain. It's basically just a giant cat emporium that my dad started to help rescue tigers and lions and other large cats. It's like a giant cat sanctuary, basically.
Now, who opened Wild Wildlife?
My dad did. He worked his whole life. This is his dream. He started off just selling used cars to try to earn money so that one day he could open it, and he finally did.
Now, you mentioned earlier that your dad went missing. When was the last time you saw your father?
That was August 17th, 2012.
Where were you at the time?
We were at work. It was a Friday.
Was anyone else at work with you?
The defendant was.
What was the last thing you remember your father saying to you?
Objection. Calls for hearsay.
Response?
Your Honor, may I assume, I just want to clarify your earlier ruling that every response will be had at sidebar constructively?
That is confirmed.
Yes, Your Honor. This is not hearsay. I'm sorry, Your Honor, this is admissible hearsay under Rule 8033, then existing state of mind, as if allowed to continue, Ms. Donaldson is going to say that her father said she could come over on Sunday for dinner, otherwise he would see her on Monday. That just goes to his plan.
I'm sorry, he said, come over for dinner, otherwise I'll see you on Monday?
Yes, he says, I'll see you on Monday, unless you want to come over for dinner on Sunday.
Okay. Response?
Your Honor, whatever he said about having dinner, I don't think goes to his intent of what he was going to do for the weekend, other than that dinner.
I mean, Mr. Jones, I tend to agree. I'm not sure this is a plan necessarily under 8033, you come over for dinner.
Sorry, Your Honor, may I respond?
Certainly.
By saying that, would you like to come over for dinner on Sunday, he's stating that he plans on being home on Sunday. He wouldn't be able to have dinner with his daughter on Sunday if he was not planning on being there.
Okay, I understand that. I tend to agree that this is hearsay. I'm not sure if it's under that exception. Having said that, you can probably ask the witness, what her weekend plans were, and if she wants to get into that she was going to go to her father's house and ended up not, or whatever it may be, that's fine. But perhaps let's not elicit actual statements.
Yes, Your Honor.
So I'll sustain that objection.
Now, Cam, what was your plan that weekend after you saw your father on Friday?
Well, I mean, I thought I was just going to see him on Monday, but I had an invitation for dinner on Sunday. But that Friday, that was the last time I ever saw my dad.
I'm sorry to hear that, Ms. Donaldson. I want to focus on the defendant's relationship with your father. What was the defendant's relationship to your father?
Well, they were married.
And how long were they married?
I think it was about 11 years.
Now, during those months leading up to the last time you saw them, were you able to see them together?
Yes, a lot. We all worked together at Wild Wildlife.
How was their relationship?
From what I saw, bad. I heard fighting.
Objection, speculation.
Response.
Your Honor, this is not speculation. She's simply testifying to the facts of what she saw, which are her rational perception. If allowed to continue, she's going to say that she saw arguments, which is something that everyone has seen before and something that everyone would know.
I think that's a fair question. That'll be overruled.
Yes, Your Honor. What was their relationship like?
From what I saw, it was bad. I heard fighting all the time. Sometimes they were screaming so loud that I could hear them from the.
Objection. This is hearsay, Your Honor.
The screaming part?
And the argument, just generally speaking. I expect her to get further into it as she progresses.
Gotcha. Mr. Jones, response?
Your Honor, I rest on my previous argument that as of right now, all she's talking about is an argument. I'm not sure what the opposing counsel means when she says that she thinks that she's going to get more into it.
Okay. I think it is fair for the witness to testify that she's heard screaming and arguments and all sorts of things. If she's going to get into the facts of what was said, I do think that it's possible those need to meet hearsay exceptions. So overruled for now.
One more time, Ms. Donaldson, I apologize. What was their relationship like?
So I would hear screaming all the time. Sometimes it was so loud that I could hear it when I was in the office in the room next door.
And does any of their arguments stick out to you in particular?
Yes, the one I remember most distinctly happened about 2 weeks before I last saw my dad.
And what did you hear in that argument?
In that argument, I just heard yelling and screaming like I had heard before, and I heard my dad yell that he wanted a divorce.
Objection. I'd renew that previous objection at this time.
Response?
Your Honor, the hearing of the divorce is admissible hearsay as it goes to the existing state of mind. And separately, it also goes to show the effect on the defendant. We're not admitting this to be true. We're just admitting that it goes to our theory, which is that the defendant refused to take no for an answer, and instead he wanted a divorce and she took matters into her own hands.
Okay. Based on that response, I'll overrule the objection and allow the statement.
Yes, Your Honor. Ms. Donaldson, what did you say that you heard in that argument?
I heard my dad tell Karen that he wanted a divorce. Then I saw Karen storm out of the room, and a few minutes later, my dad walked out.
And what did your dad look like when he walked out?
When I tell you I've never seen him look that way before, he was shaking. I could see it. He was so visibly shaken up. I was immediately concerned.
And when you saw him like that, I mean, what did you do?
I asked my dad if he was okay.
And how did he respond?
He told me that if anything were to ever happen to him, to have the police look at Karen because she will be the one responsible for his death.
You told us earlier that you saw your father at Wild Wildlife on Friday, August 17th. Was that the last time you were at Wild Wildlife?
No, I actually went there, I guess, less than 2 days later.
Why did you go there, so soon afterwards?
Well, it was a Sunday morning around 6 a.m. and I got a notification that the alarm was going off at Wild Wildlife. So I immediately drove over to see what was going on.
And when you got there, what did you see?
I was shocked to see that the front gate, which has like a lock to keep people out, was completely broken. And when I went inside, the back door was smashed.
Your Honor, there are two photographs in the exhibit binder, the broken lock and a broken fence. I'm going to mark these two exhibits as exhibits 2 and 3 respectively. Opposing counsel already has copies of these exhibits. May I ask Ms. Donaldson to bring out her copy?
Yes.
Ms. Donaldson, let me know when you have your copy available in front of you.
Okay, I have it.
Do you recognize exhibits 2 and 3?
I do.
What are they?
Exhibit 2 is a picture of the padlock that keeps the front gate locked, and then that exhibit 3, that's a picture of the back office that was broken into.
Now, do these photographs fairly and accurately depict the broken padlock and the back entrance as you saw them that morning?
Yes.
Your Honor, I move exhibits 2 and 3 into evidence.
Any objection from Ms. Maxwell, defense?
No, Your Honor, no objection.
Okay, they shall be admitted.
Your Honor, permission to screen share these exhibits.
Granted.
Now, Ms. Baja, what are we looking at here?
This is the padlock that used to go in the front of the gate to lock it from people coming in.
And how about the next exhibit? What is this?
So that's the back part of the office that gate smashed in.
And both of these pictures fairly depict what you saw when you walked in that day?
Yes.
Thank you, Mr. Dorash. Now, Ms. Donaldson, who did you see when you got to Wild Wildlife and you saw the entrance broken into?
Objection, compound question.
Who did you see? I'm sorry, I'm not understanding how it's a compound question.
That's fine, Mr. Jones. I'll address it. Your question was, who did you see when you came to Wild Wildlife and saw this broken into?
Yes, Your Honor.
Okay. That's overruled. Thank you. Go ahead.
Ms. Donaldson, who did you see when you got to Wild Wildlife and you saw that the lock was broken?
I saw Karen Baja.
Was anyone with Karen?
Yes, some man I'd never seen before holding lock cutters.
And what was Karen doing?
He was holding a lockbox that had my father's will in it.
And how did the defendant appear?
He was smiling.
Now, you said that the lockbox contained your father's will. How do you know?
I know because I was the one taking care of it. I normally kept it in the bottom drawer of my desk in the office.
And did you ever see that will again?
Not since I saw it in Karen's hands.
Now, after the will was taken, who received your father's assets?
Karen did.
No further questions, Your Honor.
Thank you, Mr. Jones. Cross-examination, Ms. Maxwell.
Yes, Your Honor. Donaldson, I just have a few questions for you. I'd like to talk about your father first. He was a pilot, right?
Yes,
And he had multiple planes.
he did.
He traveled often.
He did.
You didn't go with him every time.
No, I usually didn't.
Now, your father bought and sold planes all the time, right?
Right.
And he never properly registered them.
I don't know that he never did, but towards the end, his license was suspended, so I don't think he did then.
So his license was suspended, and at least some of the time, he didn't register his planes properly.
Yeah.
And during that time, he wouldn't have filed flight plans either, right?
I mean, I don't know. I guess he wouldn't.
Nobody, including you, knew how many planes he had at any given time.
I can't say what anybody knew. I didn't know how many planes he had.
Okay, you didn't know how many planes he had.
No.
Now, I'd like to talk about your role at the sanctuary. You were your father's assistant, right? And in that role, he had you do things like answer the phones.
Yeah, and I was the bookkeeper of all the financial records. My dad used to always say I knew the business better than he did.
And you had been in that position for 20 years, right?
Yeah.
And you never held any other position at Wild Wildlife.
No, not really. That was mainly what I would do there.
No, you had been in that position for longer than your father had even known Miss Baja, right?
I guess so, yeah.
And Miss Baja was 20 years younger than your dad?
Yes.
And when your father met Miss Baja, he was still married to your mother.
Yes,
In fact, he left your mother to be with Miss Baja.
that's right.
Now, shortly after Miss Baja took control of Wild Wildlife, she fired you from your position.
Right, after I worked there for 20 years.
And that upset you.
Of course.
You believe that the cat should be under your control, right?
Yeah.
No, it wouldn't be unfair to characterize your feelings toward Miss Baja as hostile, would it?
No, she killed my father.
Well, you've wished violence against her, haven't you?
Not before she killed my father. I never felt that way. But now knowing what she did, I know it's probably wrong of me to feel that way, but it makes me really angry knowing what she did.
I do want to talk about some of the allegations that you made on direct examination.
Okay.
As you just stated, you believe that Miss Baja was involved in your father's disappearance.
Yes, definitely.
But as far as you know, she's never been taken into custody.
I'm not on the police force.
Objection, Your Honor. Relevance?
What's the relevance of this, Miss Maxwell?
Your Honor, this just goes to show that she wasn't arrested in connection with this disappearance, and this witness would have been aware of that fact.
Your Honor, if I may reply.
Please.
It's not relevant whether she was or was not arrested. People are arrested for many different reasons and not arrested for many different reasons. I believe the opposing counsel is trying to elicit the fact that because she wasn't arrested, she didn't do this crime, which would be improper.
Miss Maxwell, I don't want to tank a chapter of your cross, but I tend to agree. I don't think the police's analysis of probable cause amounts to anything in a civil wrongful death case. In fact, I think it might mislead the jury to where they might place weight on the police's conclusions that Miss Baja did not have anything to do with the disappearance. So I can't let that in. That's going to be sustained.
Yes, Your Honor, I'll move on. I do want to have a quick clarification, though, for later on in the trial. Would it be proper for me to ask about what Miss Baja, as the defendant, her interactions with police, purely to show that she was cooperative with the investigation?
Absolutely.
Perfect. Thank you, Your Honor. Now, Ms. Donaldson, you're aware that no body was ever found.
Yeah.
Now, on direct, you mentioned a morning shortly after your father disappeared, around August 19th.
Yes. Mm-hmm.
Now, you said that you arrived at Wild Wildlife and you saw Miss Baja there.
Yes.
And when you saw her, she didn't have any injuries to her person.
I don't think so. I didn't get close to her, though.
Well, you don't remember any injuries that you noticed that day.
I think I would have noticed if there was a gouging wound, and I didn't see anything like that, but I wasn't close enough to know.
Well, you were close enough to see that she was smiling and note many other details about her, right?
Yeah, of course, but I can't see beneath her clothes or anything like that.
Right, but from what you observed, there were no obvious injuries to Miss Baja's person. Now, you told us that your father's will was in the lockbox that you saw her carrying.
That's right.
There are no copies of that will here for the jury to see today, are there?
No, because Karen took it.
There are no witnesses to that will testifying today either?
I don't think so. Just me.
Now, You first saw your father's current will and testament a few weeks after that morning, right?
I first saw it, you mean?
Yes, his current will and testament. The first time you saw it was a few weeks after that morning.
Yes,
And you had already been fired at that point.
I had.
And that was before the will was in effect.
Yes.
So Ms. Baja had the authority to fire you before she took control legally of Wild Wildlife, correct?
Yeah.
Now, you didn't initially hire anybody to look into your father's disappearance, did you?
No, I assumed the police would handle it.
You didn't hire anybody in 2012?
Right. The only time I hired.
Objection, Your Honor. Relevance again for the same grounds.
The hiring of someone in 2012 to look into this? Is that
Yes,
what
Your Honor.
Ms. Maxwell?
Your Honor, this doesn't go to anything remotely close to what the police investigation may have been going towards. This is simply to show the timing of this witness's interest in investigating this crime and that proximity to the financial interests in this case.
If I may respond briefly, Your Honor.
Briefly.
If allowed to continue, I believe that they are trying to speculate as to the facts of whether Ms. Donaldson was prudent enough in ongoing an investigation privately, regardless of the fact that the police, who are supposed to be hired to do investigations, did not do their job as well as they could. Ms. Donaldson, it's not relevant as to how soon or not Ms. Donaldson was able to hire someone. And I believe if the jury hears that, it's going to prejudice them.
I appreciate the arguments, Mr. Jones, but I do tend to agree with Ms. Maxwell that this is relevant. It is important to show what Ms. Donaldson did or did not do with her concerns. So I'm going to let that in.
Ms. Donaldson, I'll ask that question again. You didn't hire anybody to look into your concerns in 2012?
No, I didn't hire anyone until 2017. I assumed the police were on it before then.
But you hired somebody in July 2017, and that was a month before your father's will would be able to be executed?
Yes.
And just shortly before his life insurance policy would be able to be paid out?
Yes.
Thank you, Ms. Donaldson. No further questions.
Thank you, Ms. Maxwell. Redirect.
Yes, a brief redirect, Your Honor.
Go ahead.
Ms. Donaldson, on cross, you were asked whether your father flew planes. When your father would fly, what would he tell you?
Objection calls for hearsay.
Response.
Your Honor, this does not call for hearsay, as it is a party statement that's being entered. I'm just asking what her father would tell her whenever he would go flying.
Mr. Jones, the only issue I have with that is her father is not a party to this case. And even if he was, he would probably be your party. So it's not 801 D2A. But why don't you constructively tell me what it is that the witness would say?
Yes, Your Honor.
And we can decide if it's admissible.
Your Honor, if allowed to continue, Ms. Donaldson is going to say that he would always tell her whenever he was going to go flying.
Okay. And what is the relevance of that?
It's relevant as to whether or not he told her that he had plans to go anywhere. It's opposing counsel's argument that he went off flying that weekend and never returned for whatever reason. I'm just trying to establish the fact that Ms. Donaldson, it was a pattern that he would always tell his daughter whenever he was going somewhere. And this time he didn't tell her anything.
Okay. For that limited purpose, I am going to let it in, but great objection, Ms. Maxwell, overruled.
Ms. Donaldson, on cross-examination, you were asked whether your father flew planes. Whenever your father would fly, what would he tell you?
He always told me when he was leaving.
And on August 17th, did he tell you he was going anywhere?
No.
Now, prior to today's trial, have you seen the photographs of the interior of your father's van that was left at the airport?
Yes, I have.
Your Honor, I'm marking this file as Exhibit 4 for identification purposes. Opposing counsel has a copy. May I ask Ms. Donaldson to bring out her copy?
Sure, and we can always assume that procedure. The witness can always bring out their copy.
Yes, Your Honor. Ms. Donaldson, what is Exhibit 4?
That's a picture of the interior of my dad's van.
And is it a fair and accurate depiction of that picture?
Yeah, it is.
I offer Exhibit 4 into evidence.
Any objection, Ms. Maxwell?
No, Your Honor, no objection.
Shall be admitted. Exhibit 4 is received.
Now, Ms. Donaldson, what is Exhibit 4?
That's the inside of my dad's van. That's the passenger seat. I used to always ride there. And right there, those are my dad's glasses. And next to them are my dad's keys.
How often would your father wear these glasses?
I never saw him go without them.
No further questions, Your Honor.
Okay, thank you, Ms. Donaldson. You may step down or whatever it is that you do to turn your video off. And I think that, we're cruising along pretty well timing wise. I am okay taking the next witness right now, and then we can do maybe a longer break between the two cases in chief, unless anyone feels like they need a couple of minutes now. And if you do, feel free to send me a chat. Otherwise, in about a minute, we'll start with the next witness.
That works for us, Your Honor.
That's fine with me as well.
Great. Yeah, I prefer to do a little bit of a longer break. Okay, so why don't we go ahead and call the next witness. Plaintiff, you may do that, but just give me 1 second to turn a light on because it is getting dark in Florida. So
No
just give me
problem.
1 moment.
No problem.
Okay, thank you for that. I am ready. Plaintiff, please call your next witness.
Plaintiff now calls Taylor Pride.
Okay. Hello, Ms. Pride.
Hello, can you hear me?
Constructively pre-sworn. And so, Ms. Stern, without further ado, I'll leave it to you.
Good evening. Please introduce yourself to the jury.
Hi, my name is Taylor Pride. That's Pride.
What do you do for a living, Miss Pride?
I am a certified document examiner.
What does it mean to be a certified document examiner?
It means I have a certification and training in looking at and comparing different documents for forgeries, fraud, things like that.
How did you become a certified document examiner?
So I worked for the Pioneer Police Department for about 16 years. 6 of those years were in their economic crimes unit. And through that opportunity, I was able to take, it was a 2-week course in just being able to identify different types of handwriting analysis. That was with the American Association of Handwriting Analysis. And after that seminar, I was also able to get certified.
How did you get certified?
So the certification process, there's 4 different phases, and that's with the American Board of Forensic Examiners, or excuse me, the Board of Forensic Document Examiners. First, I have to provide my credentials, which would be that 2-week seminar. Then I have to provide references. I also have to take a proctored multiple choice exam, and I have to take a practical case assignment as well as an oral exam.
After you were certified, did you receive any further training in the field?
Yes, I take an annual 8-hour course to keep up to date on my training. I also read all the current literature, and I get recertified every 4 years.
Have you ever testified in court as an expert in handwriting analysis and document examination?
Yeah, I have. I've done that about 15 times.
For which side have you
I've
done?
done that for both the defense, prosecution, plaintiff, defendant, and civil and criminal.
Your Honor, I offer Taylor Pride as an expert in the field of handwriting analysis and document examination.
Handwriting analysis and document examination?
That's correct, Your Honor.
Any objection, Ms. Posey, to the tender?
Not on those, Your Honor, no.
Okay. Ms. Pride, you are now an expert in those two fields.
How did you become involved in this case against Karen Baja?
Cam Donaldson hired me in 2017 to look into the legitimacy of her father's will.
Are you prepared to give an opinion today regarding that will?
Yes, I am.
What did you review in order to come to that determination?
So I look at the contents of the will, the circumstances and timing of when it was signed, and I also compare known examples of Mr. Donaldson's signatures against the one that's in question, which would be the one in the will.
Are those the types of considerations that other experts in your field rely upon?
Yes.
Was that enough evidence to come to a conclusion today about whether the 2012 last will and testament was fraudulent?
Yes.
Please tell the jury what your opinion is regarding whether that will was forged.
Yes, it is my opinion that the will was fraudulent. The signature was also forged.
How exactly did you come to that conclusion?
Well, there were a couple different things that pointed me in that direction. First, it was pretty clear that there was a clause in the will that was unusual. It said "or disappeared." Second, it was the timing of when the will was signed in comparison to another document. And third, it was just comparing the signatures. It was quite obvious to me that the one on the will was forged.
So let's break those down a bit, starting with your first reason, the will itself. Your Honor, I've marked the will as Exhibit 3. Ms. Pride, do you have a copy of the will in front of you?
Yes, I do.
Do you recognize it?
Yes, it is the document that Cam Donaldson wanted me to verify.
Is it a fair and accurate copy of the will as it appeared when you analyzed it?
Yes, it is.
Your Honor, I move Exhibit 3 into evidence.
Any objection?
No, Your Honor.
Okay, Exhibit 3, which is, you said the will, correct?
Yes, Your Honor.
Okay, that will be admitted.
May I publish it using screen share?
You may.
Ms. Pride, please explain to the jury what Exhibit 3 is.
So this is the last will and testament of Lou Donaldson that I believe was forged.
And according to the will, who receives Lou Donaldson's estate?
If you look in the second paragraph there, it says Karen Baja is appointed to be the person who receives all of the property if he should die or disappear.
And you mentioned that there was a phrase in the will that impacted your opinion. What was that phrase?
Yeah, it's specifically if I die or disappear.
Why did you analyze the phrasing of the will?
Well, it's common for forensic document examiners to go over different contextual things regarding the will. And so when I was looking at that phrase, I thought it was suspicious.
How did it impact your opinion? Or in other words, for what reason did you find it suspicious?
Throughout my career as a forensic document examiner, I've looked at hundreds of wills and I've never seen that language before.
Now, I want to turn to the second basis that helped form your opinion. You said it had to do with the timing of when the alleged will was signed compared to another document. What was that other document?
That other document was a temporary restraining order.
Objection, Your Honor. This violates the motion in limine.
Ms. Stern, let's talk about that for a moment out of the presence of the witness constructively and the jury. So it sounds like you're about to get into the TRO.
Yes, Your Honor. I apologize. If I may be heard on this.
Sure.
If allowed to continue, Ms. Pride will testify that she took this document into consideration in making her expert opinion. A few moments ago, Ms. Pride testified to the wording of the will and how the language was very odd to her and how that helped her to form her ultimate opinion. She underwent the same exact analysis with this temporary restraining order and the contents found therein, as well as the timing of its signing. It is stipulated to that Lou Donaldson signed this temporary restraining order against the defendant just 2 days before he allegedly signed this new will, giving everything to the defendant. The expert certainly took that into consideration in forming her opinion as to whether the will was fraudulent, and therefore it is admissible under Rule 703.
In that case, I tend to agree with you regarding its probative value. However, here's what we will do. You need to instruct your witness not to mention the fact that it was a temporary restraining order. We are not going to get into the 3 paragraphs. I recall there were 3 in the temporary restraining order. What you can do is, and I will allow for this, assuming that Ms. Posey agrees with this stipulation. It is a proposed stipulation that, well, I guess it's not a proposed stipulation. I'm going to leave that to the parties. But what I am willing to do is allow you to ask the witness, did you review another legal document that had a particular date and a signature of Mr. Donaldson? And then we will constructively redact everything in that TRO minus the date and the signature. And then you can elicit the stipulation that you mentioned the parties have, that this signature was of the defendants, dated 2 days before. And what I will allow you to ask the witness is that, what is this a legal document filed in a legal court? Would that suffice to work for the purposes that you are trying to use the TRO?
I'm happy to comply with that, Your Honor, but I will say that I think that it is rather probative that it's known that this had at least some sort of negative connotation to it rather than just a legal document. I think that the jury, it will really it won't resonate at all with the jury just saying that it's a legal document. I mean, it could be anything there, as Your Honor is aware.
I sense your concern, and that is exactly why I want to keep that negative connotation out of the jury's minds, because then that would violate the propensity rule. So I don't think that it is appropriate for this trial to bring in a TRO or an MPO or anything protection-wise just to make the jury be like, wow, she must have been a crazy lady. I mean, we're outside of the presence of the jury. That's why I'm talking like this.
Yes, Your Honor.
So having said that, I do think it is valid for you to compare signatures, show a date, and then we'll go with that.
Okay, great. Thank you, Your Honor. And also, I made a mistake when I admitted the will. I admitted it, I think, as Exhibit 3, but it actually is it should be Exhibit 5. So I apologize for that. If the record could reflect that I misspoke.
That's fine.
That would be
Thank
great.
you for that correction. Thank you.
Thank you.
Please proceed.
Ms. Pride, the other legal document that you relied upon, when was that? Why did that strike you as? How did it impact your opinion?
So,
as far as the timing,
it was signed 2 days before the will.
And moving on, I want to talk about your third and final basis that helped form your opinion, the signature itself. I want to walk through how a document examiner goes about analyzing a signature for a forgery. What is the first step in that process?
So first we gather samples of any known writings.
And after, I'm sorry.
I was just saying any known writings or signatures.
And after you gather known writings or signatures, what's your next step?
Then we analyze it for characteristics. We look at how the person actually writes, all of their letters, consistencies, inconsistencies, and things like that.
What do you do after that?
After that, we just compare it to the signature that's in question.
And did you follow that 3-step process in this case?
Yes, I did.
Where did you get Lou Donaldson's known signatures from?
So first was a legal document that I pulled from the court, and the second was his driver's license.
What did you notice once you compared them to one another?
So I noticed that there were quite a few differences between those two and the will. However, those two were substantially similar.
Your Honor, I've compiled enlargements of the 3 signatures that Ms. Pride analyzed into one document and marked those as Exhibit 6. Ms. Pride, are you able to see that compilation? In front of you on your screen, I mean.
Sorry, one moment.
Please.
Yes, I do see them.
Okay, great. Do you recognize it?
Yes, I do.
What is it?
The first 2 are the signatures on the legal documents, one of which was the DMV signature, and the third signature is the signature on the will.
Is it a fair and accurate copy of those signatures as they appeared when you analyzed them?
Yes.
Your Honor, I move Exhibit 6 into evidence.
Any objection?
No, Your Honor.
Okay, shall be admitted.
Permission to publish?
Yes, granted.
What did you find when you analyzed Mr. Donaldson's signatures seen here against the signature on the will?
So one of the main things that I noticed was he typically he uses a lazy O. As you can see in the first 2 signatures, he doesn't completely write out the O. However, in the signature on the will, he does complete that O. And that's the second O that I'm referring to.
And just to be clear, you said it's the second, oh, I'm sorry, my hand is up, my virtual hand. You said it's the second O. Is that correct, the one that's been underlined?
Yes, that's correct.
Okay, and to reiterate, what is a lazy letter?
A lazy letter is one that typically in the end of signatures, people don't fully write out.
Did you notice any differences with respect to the style of the writing?
Yeah, so as far as the third one, you can tell the writing is a lot scratchier. There's even some blotching in spots. To me, as a forensic document analyst, that indicates that the person hesitated while they were writing, or they were holding the pen, kind of quivering, which indicates to me they were writing it slowly and they were comparing it to something typically for forgeries.
You said that the writer of the will lifts the pen. How can you tell that?
So in the first 2 signatures, if you look at the D is just so slightly raised in the way that they lift the pen slightly. You can tell by the pressure as well. And in the third one, it's 2 distinct strokes.
Based on the differences that you just discussed, what did you determine regarding the signature on the will?
Yeah, I determined that is definitely not Lou Donaldson's signature in the will. The signer of the will attempted to copy the signature on the TR, or excuse me, the legal document.
Thank you, Ms. Pride. Nothing further, Your Honor.
Okay, and Ms. Stern, before we go on to cross-examination, I'm sorry to make you kind of roll with the punches, but this will happen a lot, and so that's fine. And Ms. Posey, you're not going to like this, but and my apologies for not following your train of thought when you were making the arguments on the temporary restraining order earlier. The court is going to reverse its ruling for the following reason. My understanding when you mentioned negative connotation and all of that was truly that it was going to be a propensity issue where you're just showing that this is not a good lady and she's scary and people are scared of her and that kind of thing.
Right.
I understood your argument regarding the signature, but I do think that there is an exception to 404 here to bringing this in simply to show the closeness and proximity, like you asked Ms. Pride right after I prohibited you from going into that document. Because once you asked that question, the fact that a person obtains a restraining order against one 2 days before a purported will assigning all of their assets to that person I think does make it more likely that, it is relevant for the validity of the will. And I think that the exception is that you are not showing this for propensity that Miss Baja is a crazy person who does bad things. Rather, it sounds like you're introducing it to show the alleged victim's state of mind and the closeness and proximity of the TRO to the will. And so for that reason, I'm going to allow you a very limited line of questioning, and I apologize that it might have hurt your chapter on direct regarding that, to go back and ask Ms. Pride perhaps more information about when that TRO was filed in close proximity. So I'll give you another minute or whatever you think is appropriate.
Thank you.
Ms. Posey, go ahead.
May I just be heard briefly?
Sure.
It's like, because you've changed your ruling, it's totally fine that she asked about the TRO. However, I would still object to it coming in because of those three statements are particularly, prejudicial to our client.
Yes.
And would have that effect that you say. I'm fine with the line of questioning. However, I would like that TRO not actually be shown to the jury.
I mean, good point about the statements themselves. Why don't Ms. Stern, can you go ahead and publish the TRO for me real quick?
Of course. Mr. Doresh, do you have that handy?
Okay, so.
Constructively redact is fine, Your Honor.
Yeah, I have to agree with Ms. Posey because I think the comes now Lou Donaldson without an attorney respectfully requests this court to issue a temporary protection order. As grounds, the plaintiff states as follows.
Your Honor, if I may just briefly be heard as far as
Go ahead.
These statements as far as, I'm sorry, it's very, that Lou Donaldson did not feel safe because the defendant threatened to kill him are statements of his state of mind, specifically his mental feeling, and the I am seeking a divorce is his plan. Yeah.
Gosh, I'm sorry again, Ms. Posey. I know that this is not something you're going to like. I do think that it is incredibly probative for this trial to show that the victim wrote these things about a person that 2 days later had a will written in their favor. So I'm going to allow this in its entirety. My apologies for reversing my earlier ruling. It does happen, but I do think that the right evidence needs to be admitted. So I'll swallow my pride on that, and we can admit the correct evidence. And I do think this is admissible. However, we will issue a limiting instruction to the jury that says they shall not consider this for propensity reasons or to think that Ms. Baja has done something before or is the type of person that is a scary person or anything to that effect. And you guys can come up with that limiting instruction that we will issue to the jury. So Ms. Stern, go ahead and ask your questions.
And I apologize, Your Honor, for not asking to approach sidebar before questioning the witness about the temporary restraining order.
You're fine. Ms. Posey, you wanted to be heard?
I was just going to say, Your Honor, I believe that inference is made simply from the fact that he did try to take out a restraining order. I think that adding in his specific wording for why is going to still be prejudicial and misleading to that jury. So I think they can mention that he did take out a restraining order, and I think that kind of speaks for itself without needing these extra things in there.
Yeah, and that's a great argument, Ms. Posey. I really do appreciate that. I think we're going to go ahead and admit it in its entirety for now.
Yes, Your Honor.
So please proceed if you have any further questions about this document.
Ms. Pride, now that the jury is able to see this exhibit, why did this document impact your ultimate opinion?
So as part of my analysis as a certified document examiner and person who detects forgeries, particularly that the defendant wanted to take out a restraining order was concerning to me, especially when it was 2 days before the will. And the other circumstances that he indicated in the restraining order that he didn't feel safe, that he was seeking a divorce. Additionally, and that she threatened to kill him were concerning, especially because he signed it 2 days before allegedly signing the will.
Thank you, Ms. Pride. Nothing further, Your Honor.
Okay. Thank you, and we will work on that limiting instruction that this is only to be considered for the validity of the will in light of the close proximity to the TRO and nothing else. The statements will not be substantively considered for their truth. Neither will the TRO be considered for propensity. It will only be considered for the validity of the will, or the purported validity of the will, in light of the proximity of the TRO to the will. So that will be a very clear limiting instruction. Ms. Posey, cross-examination. My apologies for the detour.
No worries. Thank you, Your Honor. Now, Ms. Pride, that TRO that we were just talking about, it mentioned that Mr. Donaldson did not feel safe around Ms. Baja.
Yes, that's correct.
And it's typical that someone would want to get away from someone that they do not feel safe around.
Yes.
Now, that temporary restraining order was filed on June 12th of 2012.
Yes, that's correct.
Okay, you talked a lot about timing with that date. That was June 12th of 2012. You're aware of a bank statement that was also obtained during your investigation?
I don't quite remember that.
You do not remember reviewing a bank statement from Mr. Donaldson during your investigation?
No, I don't recall that.
Okay. You are aware of Mr. Renard's investigation into the same matter?
Yes, I am.
And you have stated previously that you reviewed similar documents as Ms. Renard?
Yes.
Okay. Well, that bank statement, Your Honor, permission to, refresh the witness, but I'd need to do it outside of the jury because otherwise I can't show her. I need to do it on shared screen.
That's fine. We can assume that you showing her the document is used for refreshing her recollection and not shown to the jury.
Okay, Ms. Pride, do you recognize this bank statement?
Yes, I do.
Okay, and this bank statement was something that you reviewed in your investigation of Ms. Baja's involvement and of the will that Mr. Donaldson created.
Yes.
Okay. Your Honor, at this time, if plaintiff will allow me, I'll go ahead through the steps to have this admitted.
If you lay the foundation for this, this is cross-examination. You're absolutely allowed to admit evidence during cross.
I just want to make sure that the witness was refreshed enough for everyone's memory. Now, Ms. Pride, you recognize this bank statement?
Yes, I do.
And you recognize it from your investigation?
Yes.
And it is a fair and accurate copy of the bank statement that you reviewed?
Yes.
At this time, the defense would move what was previously marked as Exhibit 15 into defense's Exhibit A.
Any objection from the plaintiff?
No objection, Your Honor.
Okay, it should be admitted.
Okay, Ms. Pride, now the date on that bank statement, it begins on August 1st of 2012.
Yes.
And the restraining order you just testified was June 12th of 2012.
Yes.
Mr. Donaldson's will was written on June 14th of 2012.
Yes.
So judging by this bank statement alone, we do not know that he did not withdraw money before August 2nd of 2012.
I mean, I don't know how the bank keeps.
Objection, speculation.
I think that it was a fair question because it's actually asking her that she doesn't know that. So I think that is the point of the question. So I'll overrule.
Ms. Pride, I'll ask my question again. We do not know from this bank statement that cash was not withdrawn by Mr. Donaldson before August 2nd of 2012.
Are you saying that it's like there's nothing before August?
Yes, Ms. Pride, you obtained this and you obtained this for your investigation, and it is dated August 1st, 2012 through September of 2017. There is nothing that we can see on this bank statement before those dates, August 1st, 2012.
That's correct.
Now, you're aware that Mr. Donaldson's estate was valued at $5 million.
Yes.
And this being his only bank statement shows he only had $98,727.09 in his bank statement.
Well, my understanding was the insurance policy was $5 million.
Well, Ms. Pride, you completed a thorough investigation into Mr. Donaldson, and you found out that his estate was valued at $5 million.
Yes.
And I'll ask my question again. Here it only shows 98,727.09 cents.
Yes,
Offshore accounts exist.
they do.
And you're aware that Mr. Donaldson was frequently flying off to exotic locations.
I suppose.
Okay, now I'd like to go back and mention another one of the reasons that you concluded that this was a forgery was because of the language die or disappear. Do you remember that?
Yes, that's correct. Yes, I do.
And you also found through your investigation that Mr. Donaldson was very serious about this business that he had built completely from the ground up.
Yes.
It would make sense that he would want that business protected in his absence.
Yep.
And in that will, he left everything to his wife who worked alongside him for 11 years.
Yes.
Okay. Now, I'd like to move on to the signatures that you reviewed. You mentioned that you reviewed 2 signatures, a driver's license and that TRO. Is that correct?
Yes, that's correct.
Now, in doing your analysis, you would agree that it's best to find original signatures,
Yes.
and you'd like to avoid anything that might be photocopied.
Yes.
However, the 2 things that you used, the driver's license and the court document, were in fact copies.
Are you saying the ones that I used in court or the ones in my original analysis?
Anything that you reviewed in your original analysis, those were copies.
I believe so.
Because typically when someone signs a driver's license, it's not directly on the plastic.
No.
And when someone signs that court document, you obtained a copy of it, not the original one that Mr. Donaldson put a pen to.
Yes, that's correct. But I don't always need the ink. I just look at the formations of the letters.
Well, there was also a third thing that you used in your analysis, and that was a note that Mr. Donaldson sent to his daughter.
That's correct.
That note was written from Mr. Donaldson to his daughter in May of 2012.
Yes.
This was just a few months before his disappearance.
Yes.
But ultimately, you did not use that note in your analysis.
I didn't need to because I was comparing signatures, not handwriting.
Well, Ms. Pride, typically people sign notes when they write them.
Typically, but it's also in a different manner because it's written to his daughter. It's not signing an official document.
Well, Ms. Pride, we wouldn't know what's in that note today because you did not bring it here to show the jury.
Correct.
You did not allow the jury to think for themselves whether or not that signature would be appropriate for your analysis.
No, I compared the 2 legal document signatures.
And that note was written only a few months before he disappeared, so it was a very recent document for you to have reviewed.
Yes.
Now, I'd like to talk about the way that you determined that those known signatures were appropriate. You mentioned that you used the legal document and the license, and that you were looking for similar characteristics.
Yes.
Okay, I want to go over a few of those characteristics. Permission to retrieve Plaintiff's Exhibit 5, the will.
Are you asking me that?
Yes, Your Honor, permission to retrieve it.
And by retrieve it, I guess on Zoom, are you asking to publish it? I'm not sure.
Yes, Your Honor, to share it on the screen.
Sure, yes.
Okay, Ms. Pride, let's go over the ways that you determined that the known signatures were a match. First, you determined that on the known signatures, the driver's license and the court document, that the L in lieu, the top loop was smaller than the bottom loop.
Yes.
And here in this document, you'll see that the L has a smaller loop on top and a larger loop on the bottom.
Yes.
Now, you also determined that in those 2 known signatures, the driver's license and the court document, that the U at the end of lieu has a tail embellishment. That is where the tail loops up at the end.
Right, but it's similar, but there are enough substantial differences.
I understand that testimony, Ms. Pride, but let me redirect you to my question that in those 2 known signatures, that is something that you decided was similar enough to make them a match.
Yes.
And the tail embellishment is also present here on the will.
Yes, in that specific letter.
Now, also in the letter at the end of Donaldson, the N here also has a tail embellishment.
Yes, that's correct.
And that tail embellishment was also present in the 2 known signatures that you reviewed.
Actually, one of them didn't have the letter, but that is common when someone, they might have been distracted instead of looping off their letter.
it's your testimony that Mr. Donaldson's two original signatures, the two known signatures, did not have a tail embellishment on the N?
Well, I'm talking about the loop going up. I'm not sure we're talking about the same thing.
At the end of the N on Donaldson, that N extends into a tail embellishment the same way that the U does at the end of Lou.
Yes.
And that happens here on the will just as it does in the two known signatures.
Well, if you look at one of the other known signatures, it's different.
Okay, permission to retrieve the plaintiff's Exhibit 6 from their tech. Plaintiff's tech, if I could get the Exhibit 6 on the shared screen.
Mr. Dorash,
I need 10 seconds.
No worries, take your time.
court's indulgence.
No worries.
Thank you, Mr. Dorash. Now, if you look at the three signatures here, you would agree that every single one of them at the end of Donaldson has a tail embellishment that swipes up.
Yes.
In fact, the only letter that you really determined to be any different was that lazy O that wasn't present in the final signature.
No, I also determined that the D in the signature had a different pressure indication.
Well, you also determined that that D had two separate pen strokes in all three signatures.
Right, but it was more pronounced than the last one in the will.
Okay, let's talk about that last signature. Thank you, Mr. Dorash. You can stop sharing the screen now. Now, you testified that that this last signature was scratchy or hesitant.
Yes.
And that whoever was signing it was likely hesitating or writing slowly.
That's correct.
Well, Ms. Pride, someone who's about to uproot their entire life would probably be a little bit hesitant.
I guess.
Now, I'd like to talk about the rest of your investigation. At the conclusion of your investigation, you were not able to find Mr. Donaldson's whereabouts.
No, I couldn't.
It's possible that he could be hanging out in Costa Rica right now with his mistress.
Yeah, he could also be in Florida, Japan. He could be dead.
He could have run away anywhere and not
Objection, Your Honor, speculation.
I don't think that the speculative answer actually overruled. I think that's a fair question.
I'll repeat my question, Ms. Pride. Since you said he could be in Florida or Japan or anywhere else, you're agreeing that he's not in Statesville, but that he could likely be elsewhere.
Well, I was cut off before I finished my statement. He could be in Japan, Florida, or he could even be dead. And based on my investigation, that's quite possible.
Right, he could have died in a plane crash.
I suppose that is possible. However, the circumstances that I investigated didn't lead me to that.
But that's a yes, that he could possibly have died in a plane crash.
I would disagree with that based on my investigation, but it's possible.
Well, Ms. Pride, you just said he could have been in Florida or Japan, so now you have a specific investigation conclusion that he's dead?
I suppose my understanding is that it's more likely that he's dead in my professional opinion with my investigation.
But overall, you can't say definitively where Mr. Donaldson is.
I suppose not.
No further questions, Your Honor.
Oh, sorry, I was on mute. Ms. Stern, redirect.
No redirect, Your Honor.
Okay, thank you, Ms. Pride. You may turn off your video and you are excused, subject to recall, which I'm assuming is not allowed in this forum. Why don't we take, I think we're a little bit behind. I thought that we were doing well, but I don't think we are, timing wise, and that's probably partly my fault, so I apologize. Why don't we get back on and with the defense's first witness or with any halftime motions that we're supposed to do at 8:05.
Your Honor, I'm sorry to interrupt. I just asked that the record reflect that Exhibit 5 is the will, Exhibit 6 is the temporary restraining order, and Exhibit 7 is the compilation of those signatures.
Okay, that sounds good. Thank you for that clarification. And sorry to jump the gun, Ms. Stern, I'm assuming that plaintiff does not have any more witnesses or any other evidence to present, correct?
The plaintiff rests, Your Honor.
Okay, thank you for making that record formally. Why don't we take up any halftime motions in the defense's case starting at 8:05? Everyone can turn off your video and audio until that time. All right, is everyone here and ready? I think we will, let me make sure our scoring jurors are here. We have Mr. Lag, we have Ms. Buckmelter, and it looks like all teams are here. Am I right?
I'm here. Yep.
And just for the record, you guys, I am not one of those lawyers who's sitting in bed doing this. I just moved into this apartment and I don't have furniture yet. So I'm literally sitting on a cushion on the floor with a pillow so that I'm not sitting too much on the floor. So definitely not lounging on the couch in bed or anything like that. I just
Hello, Your Honor.
Congratulations on your new apartment.
Well, thank you. I appreciate it. All right. Why don't we go ahead and take up any halftime motions, assuming that the forum allows for those. If they don't, please let me know and we can proceed.
Yes, Your Honor. At this time, the defense moves for a judgment as a matter of law pursuant to Federal Rule of Civil Procedure Rule 50. A reasonable jury could not find for the plaintiff in this case based on the case that they've already put on. The number one element that they have to prove, there are 4 elements. And the first one of that is that they have to prove that Lou Donaldson is more likely than not dead. Even their own witness today, their own expert who investigated this case, said that he probably could be alive somewhere. So I don't believe that the jury could actually find that Mr. Donaldson is dead. And then the following 3 elements hinge on the fact that he is dead because those damages must be recovered from his death, not just his disappearance. And all 3 elements hinge on that. So for that reason, we ask that this case be dismissed as a matter of law.
Thank you, Ms. Posey. Response?
Your Honor, looking at the evidence in the light most favorable to the non-moving party, in this case, us, there has been more than enough evidence submitted for this case to go to the jury. We showed the video from Exotic Bob, which includes an actual confession. Exotic Bob stated that the defendant confessed to feeding her husband to her kitties. Again, that's her word, kitties. Not only that, but Cam Donaldson also testified about what his father told him after the fight he had with the defendant regarding an impending divorce. Lou Donaldson came out of that fight and immediately told his daughter, if anything were to happen to me, make sure the police look at Karen because she will be the one responsible for my death. And that's exactly what happened because the defendant refused to take no for an answer and instead took matters into her own hands by silencing Lou Donaldson forever. And based on that, Your Honor, we have met our burden and this motion should be denied.
Okay. Well, thank you for that argument, Ms. Posey. I do share your concern about a couple of the elements, but I think that this is the way this is supposed to go. I don't think that they would have been granted with any other presiding judge anyway, but I do share your concerns, I guess, to say great argument, but your motion is denied. So let's go ahead and proceed and call your first witness for the defense.
Sure. The defense calls Chris Renard to the stand.
Okay. Mr. Renard, you've constructively been sworn, and Ms. Posey, your witness.
Good evening. Can you please introduce yourself to the jury?
Sure. I'm Chris Renard, R-E-N-A-R-D.
And Mr. Renard, what do you do for a living?
I am a forensic document examiner, and specifically, I'm an insurance claim investigator.
Who are you employed by?
Summit Life Insurance.
Okay, I'd like to break those 2 down for just a moment. First, can you tell us what you do as an insurance claim investigator?
Sure. So as the name would suggest, someone files an insurance claim if the higher ups have any reason to doubt it or be suspicious, we'll send it to someone like myself to do further investigation to determine whether or not the company should pay out to that person or investigate further or not pay out.
And how long have you been in that role?
Over 20 years.
Okay. And can you tell us about your role as a forensic document examiner?
Sure. So I apply my skills as a document examiner to the insurance claim investigation. Basically, with forensic document examining, we look into whether or not documents are legitimate or forged based on a variety of factors.
Okay, and how long have you been in that role?
Also over 20 years.
Can you tell us about your education that led you to these 2 roles?
Sure. I've got a bachelor's degree in criminology, and I went to a police academy and completed that.
Okay. Do you have any certifications in either of these two areas?
Yes, I am certified with the Board of Forensic Document Examiners as well as the Association of Certified Fraud Specialists. And in addition to that, I've also kept up with regular continued education for those roles.
And have you testified in court in either of these roles?
Yes, I've testified 25 times, and 24 of those were for this company, Summit Life Insurance, and one of those times was for the prosecution here in Statesville.
Thank you, Mr. Renard. Your Honor, at this time, the defense moves to tender Mr. Renard as an expert in insurance claim investigation and forensic document examination.
Your Honor, we have no objection to the document examiner. However, we don't believe that insurance investigations is a real field that is looked at by the court. We believe if allowed to continue, Mr. Renard is going to comment on the police investigation, which would be improper for him to do so. And if that's what he's going to be commenting on today, we would like him not to be entered into as an expert.
Would you like to voir dire, Mr. Jones?
If necessary. I'm sorry, Your Honor?
Would you like to voir dire the witness on his expertise in the insurance scope?
If he is going to be using that scope to talk about the police investigation, I would like to voir dire. However, if he's just going to be talking strictly about the documents and anything having to do with the insurance claim, I have no issue.
And what I'm going to do in that case is accept Mr. Renard as an expert in both of those areas tendered by the defense. But if he starts going into areas that you, Mr. Jones, believe is outside of the scope of the tender, then please object at that time and we will take it up.
Yes, Your Honor.
Okay. May I proceed, Your Honor? All right, Mr. Renard, I'd like to talk about your investigation in this case. Are you familiar with a policy for a Lou Donaldson?
Yes, I investigated that claim.
And how did you become involved in that claim?
Well, my boss, Mr. Wilcox, he had some suspicions about the claim, passed it to my desk, and I investigated from there.
What type of suspicions do you have about the claim that you needed to investigate?
Sure. The specific suspicions in this case were whether or not Miss Bazia, how do you pronounce it?
It's Baja, Mr. Renard.
Baja, sorry about that. I see it in writing all the time. But whether Miss Baja killed Mr. Donaldson, which would, of course, negate the need to pay the claim, and whether Miss Baja forged the signature of Mr. Donaldson on the will, the last will and testament.
Okay, let's first get into your investigation of that first part of whether or not Miss Baja was involved in this disappearance. So sure. First and foremost, what was the first step in investigating that?
The first step was to look and see if there had been another investigating body who had determined anything about it. So I looked to the police.
Objection, Your Honor.
What's your objection?
He's going outside the scope of his expertise. He's talking about the police investigation, and I believe if he's allowed to continue, he will talk about whether what the police did was proper. Mr. Renard has no experience doing police investigations or murder crimes, and thus it would be improper for him to testify about them.
Ms. Posey.
Yes, Your Honor. I believe opposing counsel is getting ahead of himself. We actually won't be talking about any of that at all. We'll be talking about the police investigation because Mr. Renard did do that investigation throughout. I mean, he's an insurance claim investigator. Like he said, he has to determine whether or not the beneficiary had any involvement in the death because that would negate their claim to that person's insurance payout. So he's not going to get into whether or not they did a proper investigation or even really the details. He's just going to say what conclusions were given to him in order to conduct his own investigation.
Then I think in that case, Ms. Posey, you might want to ask a couple of foundational questions of the witness to establish that as part of his work, he has to look at things like police investigations and whatnot to come up with his conclusion. Basically, the response that you just gave me, if it comes out of the witness, then I think it establishes sufficient foundation to go into those facts. So I will overrule that objection, but if it goes too far, Mr. Jones, and he starts diving into whether cop A did a good job or a bad job or whatever it may be that you're concerned about, please object, because I will agree with you at that time.
Mr. Renard, in your 20 plus years of insurance claim investigation, what types of things do you rely on to find out whether or not a beneficiary should be paid out?
Sure. So I would look at, like I said, any other investigating body. If they completed an investigation, I would definitely want to consider what they looked into and what they found. For example, we've been discussing the police investigations. That's definitely something that I would consider, whether they reached any conclusions. Similarly, if any other insurance companies have had to investigate the claim, I would look at those as well.
Okay.
In addition to that, I would take my own, in certain cases, I would take my own, interrogations of witnesses, look at physical evidence myself, things like that.
And are you aware how long it had been between the time that you were investigating this and the time that Mr. Donaldson went missing?
5 years.
5 years. So over those 5 years, were you able to be at the scene yourself whenever he first disappeared?
No, I had no involvement whatsoever with any of the facts of this case until August of 2017, when this policy and claim came across my desk.
So what types of things did you have to investigate with the police surrounding Ms. Baja's involvement?
Sure. So I looked into what the police investigated. They did not ever include Ms. Baja as a suspect, which I was
Objection, Your
surprised.
Honor. Motion to strike that testimony. We've already talked about, I've already objected to the fact that they can't say that she was never arrested, as it would be more prejudicial than probative, and you've already sustained that objection.
I do believe that we weren't going to get into whether Ms. Baja was arrested. And so I think I will sustain that objection.
Your Honor, if I may.
Sure.
That objection was a hearsay objection about the police investigation, but this witness is an expert. They are allowed to rely on that hearsay in order to make their own conclusions. That can go to the jury and the admissibility of that credibility. However, he's allowed to rely on things like whether or not she was charged and whatnot to go along with that. We're not necessarily asserting that just because she wasn't charged, she's not guilty, because this is a civil suit and not a criminal suit. However, he does need to be able to tell the jury what he relied on in his investigation.
Sure.
And the jury can determine that.
I think that because he testified that he relies on this to form his conclusion, he can then say something more vague, like there was no criminal case that emerged from this. I think that is fair. But to go into details of arrests or taken into custody or no arrests or charges or whatever, I think that's getting into prejudicial information that is essentially irrelevant.
I understand, Your Honor. And to clarify, is he able to talk about the police investigation in general, such as what was found or what wasn't, regardless of whether it was found in terms of Ms. Baja or not?
Yes, to the extent that those actually weighed into his conclusion and that is the process he follows, which I think that he testified it is.
Yes, Your Honor. Thank you. Now, Mr. Renard, did the police ever suspect foul play in their investigation?
No, they did not suspect foul play. They found, his keys and his glasses in his vehicle. However, there was no blood, no signs of struggle, nothing that to the police indicated that there was foul play involved.
And are you aware whether or not the police ever found a body or determined that Mr. Donaldson was definitively dead?
They never made that determination, I guess, until the 5 years went by and sort of timed out.
And at that point, to clarify, are you speaking of when Ms. Baja had her husband declared dead?
Correct.
And was that through a probate court, or was that official?
I actually do not know the answer to that question.
Okay, no worries, Mr. Renard. Now, basically what I was trying to ask you is, does that necessarily mean that he's dead, or was that just for purposes of the insurance payout in your investigation?
The latter. It allows us to make a determination to pay or not pay the beneficiaries of the insurance policy. It's not actually a factual determination of whether or not somebody died.
Okay. Now, at the end of your investigation, after gathering all the relevant evidence, what was your conclusion as to Ms. Baj's involvement with her husband's disappearance?
So I don't believe that that the evidence weighs in favor of Ms. Baja having killed her husband, such that we would have grounds to deny paying her as a beneficiary with that information.
Okay, and then earlier you also mentioned that you reviewed Mr. Donaldson's will as part of this. So I want to get into that for a moment. What was the first step that you took in reviewing Mr. Donaldson's will for a forgery?
So the first step was to find some prior signatures that we could compare to the signature on the will. So I actually used the first one I found was the one that Summit kept on file from the actual policy that he signed. Have that original document with the pen rather than a copy, and then I compared that to the signature on his driver's license that was on file with the DMV.
And how were you able to determine that those two signatures were a match?
Yes, yeah, they weren't, exact replicas. They never are, but they were a match for purposes of forensic document examination.
And even though those two signatures weren't necessarily a perfect match, did you have any reason to believe that they weren't genuine?
Did I have any reason to believe that they were not genuine? No, I didn't have any reason to believe that they weren't genuine.
And then what was your next step after determining that you had known signatures?
So once I had known signatures, I could compare those to the signature on the will. So I did that. Again, none of the signatures exactly matched, but I determined that the signatures had enough similarities that we could say confidently that there was not a reason to deny Ms. Baja the insurance claim on that basis.
And did you document this comparison in a report?
Yes, I produced a report and included the signatures, my notes, things like that.
Would you recognize that report if I showed it to you today?
Yes.
Okay, referring opposing counsel and the witness to what was previously marked as a number 7. Mr. Renard, if you'll just let me know when you have that up in front of you.
Okay, yep, I have it.
Okay, do you recognize this?
Yes.
And how do you recognize that?
I recognize it because I drafted the report. I prepared my resume, it's in there as well. And then I also, these are my notes with the signatures, the copies of the signatures posted in.
Okay, and is that a fair and accurate representation of the report that you created?
Yes, it is.
Okay, at this time, defense moves what was previously marked as Exhibit 7 into evidence as Defenses B.
Any objection, Mr. Jones?
No objection, Your Honor.
Thank you, sir. Shall be admitted and will be received. Thank you.
May I publish to the jury via shared screen?
You may.
Okay, Mr. Renard, if you'll just let me know that you see that on your screen as well.
Yep, I can see it.
Okay, and now you said that you compared these two known signatures to the third signature. Can you tell us what each of these signatures that we're seeing are?
So the first signature there is the one from the policy that we had on file. The second signature, the middle one, is from his driver's license on file with the DMV. And then the third is the signature on the will.
Okay, and once you compared these signatures, what were the similarities that you found?
So there's a bunch of similarities, with any signatures, you're looking for things like loops, strokes, stroke direction, the sharpness of different points, legibility, angles. So in particular with all of them, you see similar looping, you see similar sharpness, not exact everywhere. And then overall the direction of the strokes is almost exact throughout.
And can you tell us what reasons there might be for someone signing their will differently?
All sorts of reasons. I mean, looking at these ones specifically, they were all signed at different years. So age, and people's health definitely comes into play with the force with which they press a pen, how quickly they write their signature. Physical things like what they're writing on top. If you're writing on top of a desk as opposed to something else, maybe your signature would look different because of that. Similarly, the care with which you sign the document, the writing instrument used, there's all sorts of things that can make the signatures differ.
Ultimately, was there anything that led you to believe that the signature on Mr. Donaldson's will was a forgery?
No.
Now, I'd like to ask just a few more questions about your role. You mentioned earlier that you needed to make sure that Ms. Baja was the right person to pay this money out to, the right beneficiary. If she wasn't, would your company be off the hook and not have to pay that $5 million at all?
No, we would just pay to the whoever the then determined correct beneficiary would be.
And what could result from you being wrong on this? Would your company face any consequences?
Yeah, we could face all sorts of consequences. I mean, if you paid the wrong amount of money if you paid the money to the wrong person, right? Getting that back is always extremely difficult. You know, in addition to that, we could face liability ourselves. The company could, and simply, you know, we could end up having to pay several people if we got it wrong, for instance.
And can you tell the jury how much that payout was for from Mr. Donaldson's policy?
My recollection is $5 million. Yeah, $5 million.
So quite a chunk of change. Can you tell us, did you have any reason, did you know Ms. Baja or Mr. Donaldson before this came about?
No, I did not.
Did you have any other reason that you might be biased to make that payment towards her?
Nope, just doing my job.
And who employs you?
Summit Life Insurance.
Did Ms. Baja pay you anything to testify today?
No.
So ultimately, what was that final conclusion that you submitted to your boss?
That we did not have grounds to withhold payment of the policy from Ms. Baja.
Thank you, Mr. Renard. No further questions at this time, Your Honor.
Thank you, Ms. Posey. Mr. Jones, cross-examination.
Yes, Your Honor. Mr. Renard, why don't we pick up where you left off? Under direct, you said that you had no grounds to contest the payment on Ms. Baja killing Mr. Donaldson. Is that correct?
That's correct.
But you weren't a part of the investigation, were you?
Well, I completed my own investigation.
Right, but you weren't a part of the investigation into the disappearance of Lou Donaldson.
Not the one that occurred 5 years ago, no.
In fact, you didn't even receive any information until 5 years later, right?
That's correct.
All of your nuggets of information about the defendant murdering her husband came from a contact at the sheriff's office.
Objection, Your Honor, hearsay.
Your Honor, this is not hearsay. These are his words.
Your Honor, he's relying on a hearsay statement. He's saying that he found this out from someone at the police office.
I'm not saying that, Your Honor. Mr. Renner said that.
Mr. Jones, I understand that. I think that it's arguably hearsay. I do think it is a fair question in light of the direct examination. So I'm going to let him proceed. I'll overrule that objection.
Mr. Renner, all of the nuggets of information that you received regarding the defendant's murdering her husband came from the contact at the sheriff's office, right?
That's correct.
They didn't send you any files.
No, not physical files.
They really didn't send you any information, anything physical.
Well, yeah, no, I had my contact at the sheriff's office, but I never received, you know, a banker's box of files or anything like that.
Now, in your deposition, you claimed that the police tested a meat grinder, right?
I was not deposed in this case.
I'm sorry, you don't have a deposition prior to this case?
Not to my recollection, no.
Would it be helpful for you to see the deposition that you gave before this case?
Sure.
Your Honor, may I have my tech pull up the deposition for Mr. Renner?
You may.
Mr. Dorash, when you get a moment, can you please pull up Mr. Renner's deposition?
Sure. Give me 2 seconds.
Your Honor, while we're waiting, may I be briefly heard? At a constructive sidebar, of course.
Certainly.
Mr. Renard did not give a deposition in this case. He gave a statement to his boss, which is what I believe opposing counsel is referring to, and bringing that up on the screen for the jury to see would not be admissible.
Oh, this would not at all be something that is shown to the jury or even me. In fact, I'm not sure if Mr. Jones is trying to impeach Mr. Renard or refresh his recollection.
I'm just simply trying to refresh his recollection to the statement that he gave prior to coming to testify today.
Okay. It sounded to me like you were trying to remind him of the fact that he took a deposition. And if you want to show him a deposition transcript to remind him of that, I'll let you certainly do it. But if you ask him about a particular statement and he doesn't remember it, I'll let you show him pretty much anything to refresh his recollection. And so I'm going to give you a little bit of leeway, but Ms. Posey, you're right. It's not going to be shown to anyone at this stage unless it becomes appropriate to do so. So, Mr. Jones, your witness.
Yes. Mr. Durash, were you able to pull up the statement by Mr. Renard that he made prior to coming to testify today? Thank you, Mr. Durash. This is the statement that you gave. Is that correct, Mr. Renard?
This is my report. You asked me if I had been deposed, which I had not been. I was not deposed for this case.
I apologize for misspeaking, Mr. Renard. In this report, you do, Mr. Durash, you can pull that down. In this report, Mr. Renard, you did say that that the police tested the meat grinder, right?
Yes, the police did test the meat grinder, and they found that that there was no human DNA or blood on the meat grinder.
But you don't actually know that for a fact, do you?
I do know that.
Well, you know, in your report, you said that you gleaned that they did this.
Right.
So if you only gleaned that they did it, then you don't know it for a fact.
Well, you know, we infer all sorts of facts every day, Mr. Jones.
So are you trying to say that you know for a fact because you saw a report, or that you gleaned of a fact through a contact at the office?
Well, Mr. Jones, wouldn't they have arrested Miss Bagia if there was human blood on the meat grinder?
Mr. Renard, I appreciate your question. Unfortunately, I'm actually the one asking the questions here, and I'd like it if you'd answer them. If you could just tell me, did you glean that there was a DNA check, or do you know it for a fact because you received some information?
I received information that led me to believe that there was no blood or human DNA on the meat grinder. I think that answers the question.
Let's move on, Mr. Renard. Now, you were in the room when Taylor Pride testified, is that correct?
I don't believe, I guess I don't, was I sequestered, Your Honor?
There was no sequestration order. I don't know if you happen to be the expert who sat advisory with your counsel. I assume so, but there was no sequestration order.
Okay. I was not sequestered, so yes, I was here.
So you know that Ms. Pride is an expert in handwriting analysis and document examination.
I know that she claims to be.
You also know that she is an expert. You know that she has a certification by the American Board of Forensic Document Examiners.
Objection, Your Honor, relevance.
Mr. Jones?
This is very relevant to make sure that Mr. Renard was properly listening when Ms. Pride was giving her testimony. This is the last question I'll be asking in regards to the qualifications of Ms. Pride.
I'm going to give you a little bit of leeway, probably not a lot, so that you don't over bolster your expert through another, but I will give you a little bit of leeway. I think that that's fair. You may proceed.
Mr. Renard, you heard that Ms. Pride, she was certified by the American Board of Forensic Document Examiners.
That sounds accurate.
And it's the same certification that you hold.
That is the certification that I hold, yes.
Ms. Pride, she looked at Lou Donaldson's signature on the will, right?
Objection, Your Honor, relevance. He can't testify as to what the other witness did. It's not relevant as part of his testimony. They can bring that up in closing if that's the point he's trying to make.
I actually Thank you, Ms. Posey. It's a good train of thought. I actually do think it is. I think it is fair for an expert to discuss the findings of another expert so long as they know about them, whether it was listening to them in court or reading their reports. I think that's a pretty fair game. So I'm going to give him a little leeway. Thank you.
Mr. Renner, you heard that Ms. Pride, she looked at Lou Donaldson's signature from the will.
I believe so. To be honest, before we get too deep here, I was not paying attention while she testified, and I haven't read her report.
No problem, Mr. Renner. Let me tell you, she did, in fact, look at the signature on the will, and she testified today that she compared it to another. Now, being a good document examiner yourself, you did the same process, right?
I compared the signature on the will to prior examples. Yes.
That's right. Your Honor, may I be permitted to show on the screen the document that has already been admitted as Defense Exhibit B?
You may.
Now, this is your document that you created, correct?
That's correct.
It's the full document that you created, right?
This is one page of my report.
That's right. And at the bottom of that page, you have notes.
Yes.
Now, in those notes, you said that there could be differences in the signature, right?
Yes.
You said that you could not say for sure whether the signature was genuine.
Objection, Your Honor. This is an improper impeachment, not showing the full statement.
Just-
That's fine. I think I'm gonna let him impeach, and you'll have a chance to redirect on that point. Go ahead, Mr. Jones.
Mr. Renner, in those notes, you say that you could not tell whether the signature was genuine.
Or non-genuine.
You also say, in your own words, that it's possible someone tried to copy him.
Could be. It could be possible that you tried to copy him, you know?
And at best, the findings that you had were inconclusive.
Yeah, in that I couldn't determine whether it was 100% genuine, 100% non-genuine.
Right, you couldn't tell whether it was 100% genuine or non-genuine, and yet you decided to still pay out the claim, right?
Right, it's more likely than not that she didn't kill him and that she didn't forge it.
I understand. Thank you, Mr. Dorash. I'm actually going to move on to the witnesses of the will now. One of the witnesses to the will being signed was the defendant, right?
That's true. She was the second of two witnesses.
And the first of the two was a woman by the name of Samantha Lane.
That's correct.
Now, Miss Lane and you had a conversation, isn't that right?
Yeah, we spoke in person.
Now, Your Honor, before I continue, I know it was stipulated that we would talk about the content of the letter that Mr. Renner received. I just wanted to bring up the fact that I'm going to be talking about that now, the content of that letter.
Okay, and then the original motion that we took up was regarding the letter and any oral statements that she would have made, correct?
Yes, the oral statements were actually made to Ms. Pride. I won't be talking about that here with Mr. Renner. I'm only going to be talking about what he received, which was the letter and the contents of the letter and how he actually disregarded that letter.
Okay. Ms. Posey, do you have any final objections to the admissibility of that letter?
Yes, Your Honor. He obviously is an expert, so he can testify as to his investigation. However, the contents of that letter are extremely prejudicial, and because we cannot authenticate that that came from Samantha Lane, and because Samantha Lane is not here to testify in court, I'm okay with him going down that line of questioning. However, the contents of that note need to stay out. Otherwise, it risks the jury taking it as the truth of the matter asserted.
Your Honor, may I please respond?
Sure.
The content of the police investigation was also very prejudicial. However, we were allowed to let that come in and say that this was something that he relied on to make his opinion. Similarly, the contents of this are much more probative than prejudicial, and as such should be allowed to be in so that the jury can come to a determination to the credibility of this witness.
Thank you. I do think that the letter is admissible, assuming that the proper foundation has been laid. I heard him say that he relied on it. I don't know if foundation's been laid that she wrote that letter. And so
Your Honor,
if there's anything you can do to establish Foundation, I am leaning towards letting it in because it does go to the expert credibility of whether he disregarded it or not. Experts can also rely on hearsay. So if we are talking about the substantive contents of the letter, I think that's also fair game through this expert. Ms. Posey?
To clarify, so there's actually, he spoke to Miss Lane, and that's separate. And then there's the contents of this note. So he's saying he was not able to authenticate that note. And I believe what the plaintiff is trying to say is that because of they're trying to say that he didn't authenticate that and impeach his credibility. We don't need the contents of that note. They can talk about the fact that she said that she did not sign the will or whatever, but the contents, the actual physical note coming in besides just the signature would be extremely prejudicial because it risks the jury taking that as the truth of the matter. He doesn't need the actual contents of the note or what was said because it can't be authenticated.
Okay, I mean, without proper foundation, I'm going to have a hard time letting it in. And that's why I was saying I will let it in, assuming that you can lay the foundation to authenticate this letter. If that is not something this witness is going to be able to do, I think the best thing that you're going to be able to get, Mr. Jones, is to establish that he ignored a potential letter.
Yes, Your Honor.
But unless he can authenticate it, I'm going to have a hard time letting it in.
Yes, Your Honor. Now, Mr. Renard, you had a conversation with Samantha, isn't that right?
That's correct.
In that conversation, she told you that she had witnessed the signing of the will.
That's correct.
But then you received a letter, right?
Received a bunch of letters since then.
Well, you received a letter regarding the signing of the will, right?
I received, a letter that said something about the will.
And at the bottom of that letter had a signature of Samantha Lane.
I don't know whose signature that was, but it did say Samantha Lane.
And that letter was addressed to you, correct?
Yes, the letter was addressed to me.
Your Honor, at this point in time, I would like to show the contents of that letter.
Yeah, I think that enough foundation has been established. The fact that she mentioned she witnessed the signing of the will and that this witness got a letter from a person who holds the same name regarding the signing of the will. I'm going to go ahead and let that letter in. You may proceed.
Your Honor, may I request that this be proffered outside the presence of the jury? Once you see the content of this letter, you'll see that it's saying things like it's very prejudicial that she fed her husband to the cats and all these things without knowing that it's Samantha Lane. It's just going to make the jury prejudice against my client.
Your Honor, if I may be heard, I actually believe...
Let me see the letter. Let me go ahead and see the letter.
Yes, Your Honor.
I apologize, Your Honor. I was confused about the feeding the cats part. However, I expect that to come out in just a moment.
Okay, I'm going to go ahead and let this letter in as is. I do think that it meets all of the necessary rules and it's probative for the trial. So this letter is admitted. You can proceed. And then Ms. Posey, please raise any objections that may come up later.
Mr. Renard, you said this is the letter that you received, right?
Yes.
Now it says, and give me a moment here, I just have something actually blocking the screen. I just want to make sure that I get the statements correct in this letter. I don't want to mislead the jury. Now, in this letter, it's written to you. It says, "Dear Mr. Renard," right?
Yes.
It says, "I wasn't being honest when we last spoke."
Yeah, I mean, that starts in the middle of a sentence, but yeah.
It says, "I was coerced into signing the will."
That's correct.
It says, "I never saw Mr. Donaldson sign."
That's what it says.
Now, after seeing this letter, you contacted the defendant, right?
Yes.
And the defendant told you that she saw Mr. Donaldson sign and that Samantha saw Mr. Donaldson sign, right?
Yes. To clarify, there were two witnesses of the signing of the will. One was Samantha Lane, and the other one was the defendant.
And so you did contact her, and that's what she said, right?
Correct.
And after that, you tried to contact Samantha Lane.
Yes.
But you weren't able to get a hold of her.
Yeah, I tried and she never got back to me, and I tried again, but.
In your own words, it was as if she vanished.
Yeah.
And since you weren't able to get a hold of her, you disregarded that letter.
Yeah, ultimately, with all of the facts that were before me, all the evidence that I had, I decided that this probably wasn't a legitimate statement of Samantha Lane, and I went with the statement she had told me in person.
In fact, you considered the letter a hoax.
Yeah.
The last thing, thank you, Mr. Dorash, I appreciate you putting that up on screen. The last thing I just want to talk to you about is the content of the will. You read the will, correct?
Yes.
And in that will, it gave everything that he owned to, everything that Lou owned, just to be specific, to Karen Baja.
I don't really remember specifically what the terms were, but. So I don't remember, my answer is I don't remember what the specific terms of the will were.
Would seeing the will help you refresh your memory?
I guess, yeah.
Your Honor, may I just show him the will constructively just to him, assuming the jury can't see it?
Yes.
Mr. Dorash, when you get a moment, can you please pull the will up?
I mean, they also can if you want to publish it since it's been admitted into evidence already. Either way, it's your call.
Yes, Your Honor. Are you able to see that Karen Baja was the sole beneficiary of this last will?
That appears to be the case.
And you've been you've seen hundreds of wills, right?
Yes.
And you've been in this field for over 20 years.
Yes.
But this particular will, it had a phrase in there that you've never seen before.
Yes, it said, or disappear.
That's right. It says, if I die or disappear, and you had never seen that before, right?
Right. Yeah, it's my understanding that you would normally just put if I die.
And in your own words, you found that to be suspicious.
Yeah. Yep.
No further questions, Your Honor. Thank you.
Thank you. Redirect.
No redirect, Your Honor.
Thank you, Mr. Renard. Let's have any other witnesses the defense wish to call.
The defense calls Karen Baja to the stand.
Okay. Ms. Baja, you've previously been sworn
Yes, ma'am.
constructively. Thank you. And Ms. Maxwell, your witness.
Could you please introduce yourself to the court?
Yes, my name is Karen Baja.
What do you do for a living, Ms. Baja?
I run the Wild Wildlife Big Cat Sanctuary. It is my absolute passion to care for the animals there.
What is the Wild Wildlife Sanctuary?
Well, the Wild Wildlife Sanctuary is the home for the exotic cats, lions, tigers, leopards, the like. I devoted my life to advocating for the protection of these cats.
How did you get involved with big cat advocacy?
My husband Lou and I shared a passion for big cats. We both loved them so much, and we worked together to build the legacy that is the sanctuary. Since I lost my sweet Lou, the sanctuary is the greatest love that I have in my life.
Now, I'd like to talk to you a little bit more about your husband. When did the two of you meet?
We met when I was hitchhiking one night and he picked me up. I knew right away that he was my soulmate.
Were there any difficulties in the beginning of your marriage?
Well, he was married to his first wife at the time, and there was a 20-year age difference between us, so we received a lot of slack for it, but we were in love. There was no fighting that.
What is your relationship like with Cam Donaldson, his daughter?
Well, we had never really gotten along that well. She never really liked me.
Why didn't you get along with her?
She thought I was after Lou's money, but just because that's all she valued in him. She called Lou green thumb for his ability to make money.
Objection, hearsay.
Response?
Your Honor, this is a party opponent statement.
Ms. Stern, this is a statement by Cam, right?
Correct, Your Honor.
Okay. So yeah, I'll rule that objection unless there's something I'm missing. Is this the opposing party?
I withdraw my objection, Your Honor.
Thank you. Proceed.
Ms. Baja, I'll ask that question again. Why didn't you get along with the plaintiff?
She thought I was after Lou's money, but that's just because that's all she valued in him. She told me that she called Lou green thumb in front of me because of his ability to make money. But I didn't care about that. I loved him for his spirit and his love of big cats.
Were there difficulties in your marriage?
Of course, everyone has their issues.
Could you please tell us about the restraining order that Mr. Donaldson tried to have filed against you?
Oh, I know how that must look, but it was denied and dismissed for a reason. There was no real basis for it. We had gotten into an argument and I got dramatic and Lou reacted dramatically. The whole thing was denied and dropped. I loved him and I would never threaten him or hurt him.
Could you tell us what the bases for your disagreements were during this time period?
Well, Lou had a mistress in Costa Rica. It was something that we had discussed and we were working through. I loved him and I thought we might be able to work through it. But then he disappeared.
Now, I'd like to talk to you about August 17th and 18th, 2012. Ms. Baja, did you see your husband during those days?
No, one of our tigers had cubs and had rejected them. And when that happens, they need round-the-clock care. So I was in the big cat nursery on newborn duty. They were doing so great and they were so cute. But I hadn't seen Lou in days. I was fully consumed with them. I honestly wasn't sure if Lou had been home for the few days before. I had been so busy.
Was it normal for you to not know of your husband's whereabouts?
Oh yes, he had several planes at different hangars. He would take off at a moment's notice and he was particularly secretive at this time because his license was suspended. He didn't file flight plans, but he would always come back until he didn't.
Now, did you leave the nursery at all on August 18th, 2012?
Yes, I realized in the early morning hours that I needed formula and milk, so I went to the grocery store for supplies. On the way back, my car broke down.
And what did you do then?
I didn't have my phone, so I flagged someone down and I called my brother to give me a ride home back to the Cubs.
Around what time was that?
I believe it was a little after 3 in the morning.
Now, when did you realize that your husband was missing?
On August 18th, 2012, and I reported him to the police. I reported him missing to the police immediately.
Well, if it was normal for him to be gone, why did you report it so quickly?
Like I said, I had been fully consumed with the Cubs for days, so I wasn't sure how long he had been gone. I got worried. So I wanted the police help to make sure that he was safe and he was okay.
Oh, did you have any idea where he might be?
Well, I thought we were working through our issues, so I didn't think he had gone to see his mistress in Costa Rica, but I knew it was a possibility.
Did you tell police about this?
Yes, I wanted to give them as much information as possible to track him down.
Did you go to Wild Wildlife that night?
Yes, I was so worried about Lou, and to be honest, I didn't trust Cam. I wanted to make sure everything was fine at the office.
Ms. Baja, did you damage the property at all to get in?
No, of course not. I had every right to be there. There would have been no reason for me to break into anywhere on the Wild Wildlife property. The lock and gate were fine when I was there. I don't know how or why it must have gotten mangled in that way.
Did you make yourself available to police for questioning after your husband's disappearance?
Of course, it was only natural that they would question his wife. There had been some crazy theories from Cam that were thrown out.
Could you tell us what you mean by that?
Well, once Cam realized she wasn't getting any of her father's money, she started claiming that I was responsible for Lou's disappearance. Specifically, she claimed that I put his body through a meat grinder and fed him to the cats.
Ms. Baja, are you familiar with Exotic Bob?
Unfortunately, he has hated me for years because he blames me for being in prison and losing some of his cats. He would say anything to get back at me.
Now, Ms. Baja, was there any truth to the video that we saw today?
Absolutely not. I would never work with him in a million years. And I would never trade in illegal exotic animals. My life's work is protecting them.
Now, is it possible to put a human through the meat grinder on your property?
I mean, I wouldn't know, but I suppose it would be possible. But I can't imagine anybody getting away with something like that, even if they could do it.
Why is that?
It takes two people to operate the grinder. It's huge and makes a huge mess.
Now, did you make the meat grinder available to police for examination and testing?
Yes, I did. I was completely open and cooperative with them. I wanted answers about Lou just as badly as anybody, and I knew they had to explore all open avenues.
Now, Ms. Baja, did you have your husband declared dead?
Yes. I prayed for years that he would come home, but after such a long time, I realized I needed some closure. The uncertainty of it was just hanging all over my life. I always will love him, but I needed to find some kind of peace with it.
Now, I'd like to shift over to the subject of the inheritance you received. Are you aware of the plaintiff's claims regarding the will?
Yes, I've been in the courtroom and Cam has been claiming this all for a while now.
Were you aware of any prior versions of your husband's will?
No, there may have been a prior will, but I never saw it if there was one.
Now, did the relationship issues that you may have had with your husband affect your ability to work together at the sanctuary?
Not at all. Despite the issues we had in our marriage, Lou and I had a soul connection when it came to the big cats and the wild wildlife sanctuary. He knew that I would never let anything or anybody come before those cats, and that's all he wanted too. Most of all, anybody who really knew the two of us knows that he would have trusted me to continue protecting and advocating for the cats and to protect the legacy that is the wild wildlife big cat sanctuary.
Ms. Baja, what have you done with the money that you received from Mr. Donaldson's estate?
It's all going towards the home for the big cat family, just like I knew my sweet Lou would have wanted.
Now, Ms. Baja, do you have any idea what happened to your husband?
No. I still pray that he is alive somewhere in Costa Rica, living his days out happily. I wish I had answers for Cam about why he left, where he is, or what happened to him, but I don't know.
Thank you, Ms. Baja. No further questions at this time.
You know Exotic Bob, right?
That is correct.
Known him for years.
That is correct.
As the defendant in today's case, you've been present throughout the whole trial.
Yes, as I previously stated.
You heard all the evidence.
Yes.
You saw the video of Exotic Bob.
Yes, and as I previously stated, that has no merit to it. He blames me for taking his cats away, so he would do anything to get back at me.
Just to be clear, you saw the video of Exotic Bob.
Yes, as I just stated, but again, that has no merit to it. He blames me for him not having his cats anymore, and he, again, would say anything to get back at me.
Well, let's talk about what he said. You heard him say that you confessed to killing your husband by feeding him to your kitties.
That's correct. And again, that has absolutely no truth to this statement. He hated me because he blames me for his cats being taken away. And he again would say anything to get back at me.
Right. And I understand that, but I'm asking you, you heard him say.
Objection, asked and answered.
I think I'm going to give her a little leeway because, she might not be getting the focused answer she's looking for.
Ms. Baja, I'm simply asking you, you heard Exotic Bob say that you confessed to killing your husband by feeding him to your, in your words, kitties.
Yes, I heard that.
Now, you do own kitties, correct?
Yes, I now own the Wild Wildlife Big Cat Sanctuary.
And some of those kitties are really big cats.
Yes, it's lions, tigers, leopards, you name it.
And some of those lions, they're males.
Yes,
You're certainly familiar with what a male lion looks like.
Objection,
Yes.
relevance.
I'm gonna give her a little leeway overall.
You're certainly familiar with what a male lion looks like.
yes,
Your Honor, I've marked a photograph of a lion as Exhibit 9, I believe we're on. Ms. Baja, are you able to look at that photograph in front of you? I know there's a lot of exhibits in this case.
yes, I am.
Okay. You recognize what this photograph shows?
Yes,
It's a picture of a lion.
yes,
It's a fair and accurate representation of what a lion looks like.
yes,
Your Honor, I move Exhibit 9 into evidence.
Objections?
Nothing other than the relevance objection that I made before, Your Honor.
Okay, overruled. It shall be admitted.
We can agree, oh, I'm sorry, permission to publish.
Granted.
We can agree that that's a big lion.
yes,
Lions have large, sharp canine teeth.
yes,
Cats like this, they eat a lot.
yes, they do.
They eat a lot of meat.
Yes, that's correct.
That's why you have a meat grinder.
Yes, that is correct.
Your Honor, I've marked the defendant's meat grinder as Exhibit 10. Ms. Baja, you have your meat grinder, picture of it in front of you.
Yes, I do.
You agree that this is your meat grinder.
Yes, I do.
It's a fair and accurate depiction of your meat grinder as it appeared when your husband suddenly went missing.
Yes, that is the picture of the meat grinder on the Wild Wildlife Big Cat property.
Your Honor, I move Exhibit 10 into evidence.
Any objections?
No, Your Honor.
Permission
Okay,
to
it shall be
publish.
admitted. Be granted.
We agree that Exhibit 10 shows your meat grinder.
Yes, it does.
It's a large grinder.
Yes, it does.
Large
yes, it
enough, large enough to dispose of a human body.
I mean, I wouldn't know from personal experience, but I suppose so.
Right. Well, on direct examination, you said it's possible.
Yes, I believe I said on direct examination that I wouldn't personally know, but that it could possibly do it. I suppose so.
You keep this grinder at Wild Wildlife.
Yes,
As far as you know, that's the last place that your husband was ever seen alive.
I believe that Cam said that. Yes.
Let's talk about some circumstances leading up to when your husband disappeared. You two were having marital problems.
Yes, but everyone has marriage issues.
Right. Well, he filed a temporary restraining order against you.
Objection, Your Honor. Pursuant to your ruling on this exhibit, I believe that it is being used for an improper purpose.
Ms. Stern?
Your Honor, the defendant has chosen to take the stand. It's our contention that this temporary restraining order had an effect on the defendant. Whether or not it's true what Mr. Donaldson was saying, the defendant certainly saw it, and it's our contention that it put her on notice as well as gave her a motive to kill him.
I've got to say, Ms. Maxwell, I think I would have agreed with you had you not asked her on direct examination about why or what happened surrounding the temporary restraining order and allowed her to respond to that. I think because she had the chance to justify that for you, I think it's fair that Ms. Stern ask her questions on cross, so I'm going to allow.
Yes, Your Honor.
Please proceed, Ms. Stern.
Your husband filed a temporary restraining order against you.
Yes, and it was denied and dropped for a reason.
Your Honor, permission to publish to the jury.
Yeah, that's fine.
In this court document, he wrote that he wanted a divorce.
That is correct.
You agree with that one?
Yes, that's what it says.
He told you that himself.
Well, that's what it says, yes.
And he also told you that himself.
Yes.
Now, you of course deny that you ever threatened your husband.
That is correct.
You certainly deny that you killed him.
Yes, that is correct. I had nothing to do with killing my husband or his disappearance.
I want to talk about what you claim you were doing that night. According to you, you were really busy on the night that he disappeared.
Yes, one of our lions had just had cubs and they were so cute and I was taking care of them. I had been fully consumed with them for days.
Now, certainly these weren't the first cubs you've ever had to nurse.
Yes, that's correct.
But you want us to believe that on this night, on the night that your husband disappeared, you just happened to run out of milk.
Yes, that's correct. The cats are on a feeding schedule. And like I said, I had been fully consumed with them for days and we just happened to run out of milk and formula. I can't control how much they consume. It just happened.
You just happened to run out of milk at 3 o'clock in the morning.
Yes, like I said, cats are on a strict feeding schedule, especially newborn kittens. They're really cute, but they are a lot of work. I had been fully consumed with them for days. So yes, we ran out of milk and formula at 3 in the morning.
And you also claim that on your way back from the grocery store, your car just happened to break down.
It didn't happen. Yeah, it did happen to break down.
And you also claim that a Good Samaritan happened to be driving by to offer assistance at 3 o'clock in the morning.
Yes.
On direct examination, you told us that your husband would fly planes.
Yes, that is correct.
According to your sworn testimony under oath, he would take off at a moment's notice.
Yes.
He'd leave the country for periods of time without telling you.
Yes, that is correct.
And on all those occasions when you didn't know where he was or when he was coming back, you never once called the police.
Yes, that's correct.
Never reported him missing.
Yes, that's correct. But this time was different. I hadn't seen him in a couple days and I was worried. And I knew that the police could help me if there was something wrong or not. I just knew that the best thing to do was report him missing to the police.
This time certainly was different. You called the police, just to break it down a bit, a couple days, you say, after you last saw him.
That's correct.
And not only did you call the police a couple days after you last saw him, you told them he was missing.
Yes, that's correct.
And then just 2 weeks later, you showed up with a new will.
It's his will.
Well, you agree that this will, let's go back a moment. You agree that Lou Donaldson signed that temporary restraining order on June 12th, 2012.
Yes, that's what it says.
And you're contending that he then signed this not new will 2 days later on June 14th.
I'm sorry, that question confused me a little bit. Would you mind rephrasing? I apologize.
No problem. You're contending that Lou Donaldson signed a will 2 days after he signed a restraining order against you.
That is correct. He did sign.
Okay, well let's talk about that will. The will gave you his estate.
Yes.
It gave you his business.
Yes.
And as far as you know, his business alone is worth $5 million.
Yes, that is correct.
And before you met Lou Donaldson, you didn't have very much money, right?
Yes, I came from a poor upbringing, if that's what you're asking.
You also filed for his life insurance payout.
Yes, that's correct.
Worth another $5 million.
Yes, that's correct.
Sometime before you married Lou Donaldson, you knew he was a wealthy man.
Yes, that's correct.
And today you sit here as a multi-millionaire.
Yes, that is correct.
No further questions, Your Honor.
Thank you, Ms. Stern. Redirect.
None, Your Honor. May this witness be excused?
She may. Thank you. I don't know who's keeping time, but can we get a time check before we go into closings, please? Go ahead.
Do we know who was keeping time? I thought it was the woodshed witnesses, but I don't know that they're in here anymore. So
I don't. Okay, so is anyone in the courtroom right now working on getting us a time check or not? Because if not, that's fine. We'll just proceed. Does either team object to where the other team is time-wise? It seems like everyone's taken up the same amount of time, roughly. So if there are no issues for either team on timing, we'll just proceed with closings. If one team feels like the other has really surpassed their time or anything like that, let's take that up now.
I have no
Okay.
issues timing
No
wise.
objection over here.
Okay, well then we'll just assume that things are fine. And who is doing closings? Or actually, let me ask the defense. Does the defense rest?
Yes, Your Honor, the defense rests.
All right, are there any motions to take up before closing arguments?
Yes, Your Honor, we would renew our motion for a judgment as a matter of law pursuant to Rule 50. Same argument stands.
Great, and same ruling stands. So let's go ahead and proceed with closings. Plaintiff, you can go first.
Your Honor, may I ask for a brief 1-minute break before we proceed?
Absolutely. Yeah, why don't we just kind of get back on like at 9:12, 9:13. We'll just give you a couple of minutes to regroup. In fact, let's just call it 9:15. You guys can regroup and collect your thoughts, and we'll start sharply at 9:15.
Perfect. Thank you, Your Honor.
Absolutely. Are you guys ready?
Yes, Your Honor.
Yes, Your Honor.
Go ahead.
If anything ever happens to me, tell the police to look at Karen because she will be the one responsible for my death. And she was. What Cam Donaldson did not know, what she could not know, is that just 2 weeks after her father spoke those chilling words, he would be gone forever. At the beginning of today's trial, my partner told you that the reason that Cam Donaldson no longer has a father is because the defendant refused to take no for an answer. So she took matters into her own hands. Let's start with that first point. The defendant wouldn't take no for an answer when it came to her fairy tale marriage. It began when the defendant, who grew up poor, married Lou Donaldson, a multimillionaire who even had the added bonus of being a fellow cat lover. The defendant knew that with Lou Donaldson, she'd have hundreds of big cats and millions of dollars. But without him, she knew she'd have nothing. That's why when he told her he wanted a divorce, she refused to take no for an answer by silencing Lou Donaldson forever. You saw the restraining order that Lou Donaldson filed against the defendant. Of course, the defendant denies that she ever threatened her husband. She wants you to believe that Lou Donaldson lied when he sought protection from the court. He just made it all up for fun. But what the defendant can't hide from is how this request made her feel. How angry, how furious at the thought of having to get a divorce. And that's why she took matters into her own hands by murdering her own husband. Which brings me right to my second point. The defendant took matters into her own hands. Now, unfortunately, Exotic Bob was not able to testify live today. But he told us how the defendant took matters into her own hands. And listen, I will be the first to admit, Exotic Bob, the man can sing, but he is exotic. But we don't choose the victims in any given case. The defendant does. Exotic Bob told us that the defendant threatened to kill him by feeding him to her kitties, just like she did her husband. A confession that sounds like it's from a crazy Netflix series. But when we dug a little deeper, and what you have learned today is that it's exactly what she did. She fed her husband to the lions and tigers that he worked his life to protect. Something so disgusting, it's hard for me to even talk about without getting a pit in my stomach. The defendant told you about her kitties, including those big lions with large, sharp teeth. They eat a lot of meat, members of the jury. Meat that the defendant gives them when she's shredded it through her meat grinder. The meat grinder that, by the defendant's own admission, is large enough to possibly dispose of a human body. That's crazy, the defendant says. I was taking care of my sweet cubs that night. Members of the jury, you saw the defendant. You heard my cross-examination. She wants us to believe that on the very same night her husband went missing, it was just a coincidence that at 3 o'clock in the morning she ran out of milk. A big old coincidence that on the way back from the supposed grocery store, her car broke down. A coincidence that someone was just driving past and stopped on the side of the road to offer assistance. The defendant calls all of these coincidences, but the law calls them something different. The law calls them circumstantial evidence. Her Honor will instruct you that we can prove this case to you through circumstantial evidence, which really just means that you're allowed to connect the dots. And there are a whole lot of dots here, members of the jury. Of course, the defense will tell you that because we don't have a body or DNA or that the defendant was charged with murder, that means we haven't proved our case today. But this is a civil case, not a criminal one. All we had to prove was that it's more likely than not that Lou Donaldson is dead, that he's dead because of this defendant's intentional or reckless conduct, that Cam Donaldson suffered injuries because of her father's death, and that therefore the defendant is the one that caused those injuries. Through circumstantial evidence, we've done that. But the circumstances don't end with Exotic Bob, or with the lions and the meat grinder, or even with the defendant's pathetic alibi. Because the defendant continued to take matters into her own hands even after she got rid of her husband. She still had to figure out how to keep those hundreds of big cats and millions of dollars. How to make sure that no one would know about that prior will that had Lou Donaldson's actual intentions in it. But Cam Donaldson knew. You heard that just one day after the defendant reported her husband missing, she broke into Wild Wild Life and stole the lockbox that contained Lou Donaldson's prior will. And just 2 weeks later, she showed up with this. A new will that leaves Lou Donaldson's only child with nothing, and instead leaves the defendant with everything. Hundreds of big cats and millions of dollars, all for her. Of course, the defense will come up here and tell you that this will is genuine. But the testimony of the two experts, it tells us otherwise. And I'm not even going to waste time telling you what our expert had to say, because you heard Taylor Pride's opinion that this will is forged. But what occurred to me during the testimony of the defense's expert is that we may as well have called Chris Renard ourselves, because he was forced to admit that he can't say one way or another whether this will was forged. It was inconclusive, and he even said, and I wrote it down, that he wasn't paying attention when our expert, Ms. Pride, testified. He even said that it's possible that someone could have forged this will. He also said that he has never once seen the word disappear in a will before. You want to know why he's never seen it? Because he's never had a woman make her husband disappear and then put that language in a will before. But the defendant forgot something when she was making this fake document. She forgot about what date to put on here. Members of the jury, when you look at the timing of this will, time tells all. Time testified today that on June 12th, 2012, Lou Donaldson filed that restraining order against the defendant. And this new will stated just 2 days later, on June 14th, 2012. Do you really think that Lou Donaldson, just 2 days after seeking protection from the court to keep the defendant away from him, would turn around and sign a new will that gave everything to her, to the very woman he was seeking protection? Do you really think that Lou Donaldson, who had a close relationship with his only daughter, in that 2-day period would decide to completely cut her out of his will? Of course not. The defendant faked this document and thought she could get away with it. And she almost did, didn't she? But fortunately, there's one more date on the timeline of this case. And that date is today. Because today is the day that you get to help Cam Donaldson. Today is the day that you get to tell the defendant she cannot take matters into her own hands by killing someone just because she didn't get her way. So I ask you to consider, where does this all leave Cam Donaldson? Cam will live the rest of her life without a father. Her dad will never walk her down the aisle at her wedding. He'll never be a father to her grandchildren. The pain and suffering that Cam endures will be with her for the rest of her life. Members of the jury, I hate asking for money. I wish I could ask you to bring Lou Donaldson back to life, because that's all Cam would want. She'd want her dad back. But we know I can't ask you to do that. You can't do that. But because this defendant killed Lou Donaldson to keep his money, what we can do is speak in a language that she understands. A language that motivates her. Money. And in order to talk about money, we have to talk about what Cam lost. What Cam lost was everything. She lost her father, her business partner, her best friend. She lost any chance at an inheritance. She lost any chance at carrying on her dad's dream. And the only thing that can make it right is you, members of the jury. You're the only people that can make it right. At the end of this trial, you'll be asked to choose between two verdict forms. One of those forms has a $sign and the other does not. You can vindicate Cam Donaldson by choosing verdict form A and putting a number on that line. And I'm not going to tell you exactly what number you should put on that line, because I can't tell you how much a father's life is worth. But what I can tell you is that the defendant now has $10 million, even though she's the one responsible for Lou Donaldson's death, even though she's the reason that Cam Donaldson no longer has a father. But that $10 million, it's only a minimum. For good reason, there is no maximum amount that you can award this plaintiff. And I won't even insult you by suggesting a number above that $10 million, because that's your decision and yours alone. But it's time to take matters into your own hands now by finding the defendant liable. Thank you.
Thank you, Ms. Stern. Ms. Maxwell, whenever you are ready, you may proceed.
If I could just take a moment to set up my virtual well. May it please the court? Counsel. Members of the jury. We wish that we had answers for the plaintiff about what happened to her father. We wish we could tell her exactly where he went on August 17th, 2012, and what happened to him. We wish we could tell her why he chose to give his belongings to his wife instead of her. We are here today because, like so many of us do, when the plaintiff was faced with grief, loss, and confusion, she looked for someone to blame. But members of the jury, placing that blame on Ms. Baja for something she had no hand in won't give the plaintiff the peace that she is so desperately looking for. Of course, the plaintiff wants to believe that Ms. Baja is the criminal mastermind behind every bad thing that has happened to her over the past 8 years. Nobody would want to believe that their father would leave his estate to his wife instead of them, especially not when that wife is a woman 20 years younger than their father and was the reason that their parents' marriage fell apart. That would be hard for anybody to accept. So the plaintiff didn't accept it. Instead, she began concocting these wild conspiracy theories to try and explain away her father's actions that she couldn't reconcile. Now, the judge will talk to you soon, and she'll tell you that as a juror, it is your duty not to guess or speculate about a fact. So while the plaintiff has asked you to fill in blanks about what happened to her father, it's your duty not to. Just like the insurance company didn't defy the evidence to fill in those blanks, just like the probate court didn't defy the evidence to fill in those blanks, just like the police didn't defy the evidence to fill in those blanks, neither should you. Now, the plaintiff had the burden of proving 4 things to you today. 1, that Lou Donaldson is in fact deceased. 2, that if he is deceased, that his death was caused by Ms. Baja's conduct. That the plaintiff suffered injuries and that those injuries were caused by Ms. Baja's conduct as well. Now, if you feel that even one of these elements has not been proven without having to guess or speculate about a fact, it is your duty to find Ms. Baja not liable. And the first blank that they're asking you to fill in is a big one. Whether or not Mr. Donaldson is even dead. The plaintiff failed to prove even the first element of their case today because, as we heard, we have no idea what happened to Mr. Donaldson. We know he disappeared, but we also know that he wanted to get out of his marriage. We know he had a mistress in Costa Rica. We know that he was a very eccentric, very wealthy, very secretive man with multiple planes. Nobody knew how many he had, so nobody could have known where he kept them all. And that's not all we don't know. Because while you saw a bank record that showed that Mr. Donaldson didn't spend any money after his disappearance, we don't know what kind of offshore accounts he might have had or what kind of other assets he might have had waiting for him in Costa Rica. Now, the plaintiff wants to believe that he wouldn't have just up and left without telling her, but this isn't the first time that he's been swept away from family by another woman. He did the same thing to the plaintiff and her mother when Ms. Baja caught his eye. It's not crazy to think that that happened again and that for whatever reason, he didn't want to be tracked down this time. No body was ever found. You saw the picture of the glasses and the keys in his van. There was no blood, no dirt, no signs of struggle anywhere. We don't know that he's dead. It was the plaintiff's burden to prove to you today that he is. Don't fill in those blanks for them. Now, that's not to say that we know for sure that he's alive either. We don't. Maybe he didn't intend to leave his daughter or his wife forever that day. Maybe something else tragic happened to Mr. Donaldson that explains why Ms. Baja lost her husband and why the plaintiff lost her father. And we don't know what that might be. But it was the plaintiff's burden to prove that if he is in fact deceased, that it's due to Ms. Baja's conduct. And we don't know what happened on August 17th, 2012. We know that Mr. Donaldson often hopped on a plane at a moment's notice to travel abroad. We know that he didn't always tell his family where he was going, and that he often didn't file flight plans. Now, he wouldn't have been wearing his glasses, and it's not hard to imagine that a man flying unregistered planes with a suspended license without his glasses on, something might have gone wrong on that flight. Whether it was a malfunction with the plane, a problem with his vision, or some other reason that made his plane go down. Or maybe something sinister was going on here, just not with Ms. Baja. You heard the witnesses today, members of the jury. Mr. Donaldson was a secretive man who traveled abroad often and liked to keep assets hidden. We don't know what kind of activities he was engaged in, but if he got mixed up with the wrong people, isn't it possible that they caused his disappearance? Ask yourselves, what evidence have we heard today to exclude that idea? Absolutely none. The truth is, there is an endless number of possibilities about what might have happened to Mr. Donaldson. Just because the plaintiff wants you to fill in the blanks with the answers that award her the business and money she feels she's entitled to, doesn't make them the right answers. If we're filling in the blanks, why not choose any of the other possibilities? They're just, if not more, likely. Now, if you look at the rest of the plaintiff's case about why they think Ms. Baja committed this murder, none of it really makes a lot of sense. Because what exactly are they alleging? That on August 17th, Ms. Baja, while in the middle of giving round-the-clock care to brand new kittens, somehow overpowered a grown man, killed him, disposed of his body, and then drove his van to a random airstrip 40 miles away, all without leaving a single trace of evidence. You heard the plaintiff on the stand today. When she saw Ms. Baja the next day, there were no injuries to her person. There's no evidence that she committed this crime. The plaintiff wants you to buy this idea that Ms. Baja is simultaneously a criminal mastermind who pulled off the perfect crime without leaving any evidence, but then also brash and sloppy enough to create all of this suspicion around them, which they have called circumstantial evidence. Because let's look at some of the choices that the plaintiff is saying that the defendant made, or that Ms. Baja made after she supposedly killed her husband. Because they point to the fact that she reported him missing shortly after he was last seen as some big tell, right? That she knew that he was gone. But let's think about that, because if Ms. Baja had in fact committed the horrendous crime that they say she did, why would she want police attention to her husband's whereabouts as quickly as possible? Why would she call them sooner than she needed to get them looking for him? It makes no sense. Now, they also talk to you about the date on the will. And this is a perfect example of how they want her to be this criminal mastermind when it works for them, because there's no evidence showing that she actually did this, but they want her to look like a fool whenever it works for their case. Because they told you that she forgot the date on the will, that she put that date because she just forgot that it would be significant. But members of the jury, if Ms. Baja had in fact forged this will, if it's all just a fake, she could have chosen any date she wanted to put on that paper. From the day they got married, all the way through the 11 years that they were together, she could have chosen any one of those days. Why would she choose a day 2 days after she knew there was a court record documenting disagreements with her husband? It doesn't make sense. The plaintiff has asked you to fill in these blanks, but the answers that they are giving you don't add up. Now, if they had failed to prove even one of the elements in their case today, that would mean a not liable verdict at the end of this trial. But now we've seen they failed to prove the first two. And since they didn't prove those first two, the rest fall by default. Because the last two elements were that Miss Donaldson suffered injuries because of the death of her father, and that those injuries were caused by Miss Baja's conduct. Now, there was a lot of discussion about Mr. Donaldson's last will and testament, and we heard from some experts today. Now, the plaintiff pointed to the wording of this will as a huge tell that Mr. Donaldson didn't write it. But members of the jury, Mr. Donaldson was an eccentric man. He may very well have used this type of language, particularly if he was planning on disappearing with his mistress to Costa Rica. And you heard that the insurance company had their investigator analyze this will, and he found it to be genuine. Now, the plaintiff did hire their own expert, handwriting analyst and investigator. And let's take a moment to notice exactly when that investigator was hired. Because Miss Donaldson didn't initially try to have anybody look into her concerns about Miss Baja, She didn't look for answers about her father in 2012, 2013, or at all until July 2017, right before her father's will would be able to be executed and his life insurance payout would be dispersed. But aside from the motives that the plaintiff might have had in hiring Investigator Pride, I do want to talk to you about some of the specific things that she told you today. Because she said that she collected known signatures from Mr. Donaldson to compare to the signature on the will. And she collected 3 of these: the court record, the driver's license, and a note from Cam. But when she shared her conclusions with you, she only shared the analysis between the court record, the driver's license, and the signature on the will. She never talked about that note from Cam until my co-counsel confronted her about it on cross-examination. Now, this sample was the only one of the 3 that was an original, not a copy, and it came from her boss, the plaintiff herself, so why wouldn't she have run that analysis? If the handwriting on that note wasn't a match to the signature on the will, why didn't we see it today? Why didn't Investigator Pride share us the results of that comparison? Because these samples were cherry-picked to reach the conclusions that the plaintiff wanted you to reach. You are the only people who can determine the credibility of the witnesses today. And when you're considering the credibility of the expert witnesses, you should remember that Investigator Pride was hired directly by the plaintiff. When she performed her analysis and when she testified today, she was on the plaintiff's dime. Investigator Renard, on the other hand, wasn't hired by either side to run his analysis. He was working for the insurance company at the time. He had no dog in this fight, other than to make sure that the money went to the right person and that his boss didn't have to face the legal repercussions of making the wrong call. Now, if we look at every single element of this case today, we can't reach the conclusions that the plaintiff wants you to reach without filling in blank after blank after blank with exactly the answers that she wants to hear. Now, these answers were rejected by the insurance company, they were rejected by the probate court, and they were rejected by the police. So, who in this trial really can't take no for an answer? Not Miss Baja. The plaintiff can't take no for an answer, and so she has made a last-ditch effort in bringing this lawsuit to you in hopes that you will circumvent all of the other avenues and award her the money she feels she's entitled to. But members of the jury, filling in the answers that make the plaintiff feel better won't bring her father back. And putting the blame on Miss Baja for something she had no hand in serves no justice. Find her not liable.
Thank you, Ms. Maxwell. A brief rebuttal, Ms. Stern.
I'm just going to keep this. The defense wants us to believe that we haven't filled in the blanks. But members of the jury, this case isn't about blanks. It's about circumstances. It's about connecting those dots. The defense wants you to believe that Lou Donaldson flew off in an airplane to Costa Rica and just can't be found. The defense told you about his van, how that was found at an airstrip, so that must be true. But here's what the defense left out. Lou Donaldson would fly off at a moment's notice for periods of time without telling the defendant where he was going or when he'd be back. At no other time before that did the defendant ever call the police. She never reported him missing. The defendant herself said on cross-examination, this time was different. This time was different because the defendant knew he was missing because she's the one that made him die and, in her words that she put in the will, disappear. That's certainly not a blank, members of the jury. That's just one circumstance that proves our case. And let's talk about some of those other possibilities the defendant is proposing. I'll really just harp on my favorite here, that Cam Donaldson was the one that caused her father's death, that she was the one that was behind it. Members of the jury, everything we've heard today indicates that Cam and her father had a very close relationship. He was her best friend and her business partner, which is exactly why she filed this lawsuit, to get justice for her father. And opposing counsel is incorrect. We don't think that the defendant is a criminal mastermind by any means. She was hungry for money and had 100-pound cats at her very disposal. We never suggested that what she did was difficult. And when she wrote that date on the will, she messed up. Opposing counsel said herself, the date doesn't make any sense, and she's right, it doesn't. Members of the jury, for all of those coincidences that the defendant wants us to believe, if they were really coincidences, the defendant would have to be the most unlucky person in the world. But we know that she's not, because there was someone who was even more unlucky, and that was Lou Donaldson. Cam Donaldson brought this lawsuit so he could get justice, not for money, not for vengeance, not for any of these concocted reasons that the defense has come up with. And the circumstances in this case prove that the defendant killed her husband. Any blanks have been amply filled, and those that may remain still do not change the fact that it is more likely than not that the defendant is responsible for Lou Donaldson's death. Find her liable. Thank you.
All right. Well, thank you very much. Everyone can come back alive now, whoever would like to, video-wise. Great job, guys. Give yourselves a round of applause. I know it doesn't feel the same when I'm just the only one who's heard doing it. I got to say, I'm sure that Netflix will be very pleased to hear that there's a whole trial tournament after the Tiger King. So great job. I wish more than anything, and I'm sure Mr. Lag and Miss Buckmalter wish more than anything, we could chat with you for a few moments and tell you, my gosh, do this or don't do this. But for the most part, what I can tell you is you guys are great. You're off to a great start as trial lawyers and this early in your career. I was a trial team coach at the University of Denver myself, and you guys are great, off to beyond a great start. So be very proud of yourselves, and you'll get some commentary from us, I'm sure. For our scoring jurors, are you aware on how to actually submit the scoring? I'm assuming that you know where to go and how to do it. Okay.
Yep.
Great. Yeah, I just wanted to ask that question and make
very
sure.
good, very professional. Oh yeah, I'll throw in there. Very nice, very good.
Yeah. I'm very impressed. I mean, you guys are going to be able to tell lawyers in the future. Remember that whole COVID thing? We were the very first, group of young lawyers who did a trial tournament on Zoom. I really was skeptical on how this was going to work out. But my gosh, I felt like we didn't even have a glitch. So it's great. You guys are awesome.
I felt as members of a younger generation, you had a real comfort and familiarity with speaking online and looking directly into the camera to establish eye contact. And I'm of a much older generation, and I know that I and a lot of the people I work with struggle with that. So it was terrific to see that. And I thought, I agree, you all are off to a wonderful, impressive start.
Thank you all so much for being here.
Absolutely. Really get some rest, and hopefully I won't see you guys again in the next couple of days, because I don't think I'm supposed to. But I'll wish you guys the best of luck in attorney.
Thank you all.
Thank you.
Have a good night.